Why don't we all rise for the Pledge of Allegiance? Mr. Nye, if you could lead us, please, that'd be great.
Yes, sir. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Before we call the roll, would people please silence their cell phones? And with that, Melissa, if you'd please call the roll.
Robin Fisher.
Here.
Kendall Moore.
Here.
Marcia Newell. Here. Mike Herodopoulos.
Here.
Marie Rogerson.
Here.
Blaise Tredis.
Here.
Bob White.
Here.
Matt Nye.
Here.
Gabriel Jacobs Kirstein.
Here.
Tom Jenkins. Cole Oliver.
Here.
Sue Schmidt.
Here.
Jordan Chandler.
Here.
Cole Oliver.
Here.
Sue Schmidt. I'm sorry. Jordan Chandler. Vic Lubker. Dave Newman.
Here.
We have a quorum.
Thank you very much. All right, next on our agenda is the approval of minutes. Do I see any concerns there? Do I hear a second? Vic has seconded that. Objections show those minutes adopted. We have now no report from me. Why don't we go to the staff to see if there are some comments?
Yes, Mr. Chair. Just two items. You have the memo produced that shows the different compositions of the school boards throughout the state. And I received an email from the Supervisor of Elections Office that they're still working on the estimates. Had to update due to increases in paper printing, shipping, and transportation costs. They're trying to make sure we get the accurate information. It is Supervisor's directive to compile and provide this information to you as soon as possible. So as soon as I get it, since it's after the meeting, I will forward it on to each member.
Thank you very much. Any questions for the staff? All right, next we're going to move the report from our attorney, Mr. Gugelman. Your report, please.
Thank you. One of the outstanding questions was to the school board is when did the position of school board superintendent become an elected position or go from an elected to an appointed position? I did talk with the attorney for the school board. They were going to look into it and get back to us, and I have not heard anything yet from them. I suspect it was back in the 1970s. That's my best guess. There are several memos that have been presented to you regarding the 10-vote rule, proposals 6, 2 memos, 21 and 23. And rather than protract things, I'll simply say that I'm submitting those to you, and if there are any questions, I'll be happy to respond.
All right, thank you. Are there questions?
I have a quick question.
Mr. Tredis for a question.
Mr. Gugelman, first of all, I'd like to state that I agree wholeheartedly with your opinion that the right to clean water proposal is contrary to Florida statutes. But I'd like to ask you on your opinion about this civil cause of action. You say your opinion is that the county can create a civil cause of action. Is that your opinion?
Yes, sir.
Okay, I don't really have a question that other than to state my disagreement with that for the reason that Article 5, Section 5 of the Florida Constitution, which is the court system, says that, quote, jurisdiction of the circuit court shall be uniform throughout the state, end quote. And when the legislature passes a law which creates a cause of action, it's obviously statewide. If the citizens vote a constitutional amendment which creates a cause of action, it's obviously statewide. But a cause of action that were to be created by a county charter would only apply to the county, which would mean there would be 20 different judicial systems in the state of Florida if it were allowed, because you have 19 charter counties which could have 19 different legal systems with different recognized causes of action, and then the other counties would be the 20th separate judicial system with other causes of action that are recognized. So I just wanted to get my a disagreement with that portion of your memorandum on the record. And secondly, I just wanted to point out that in addition to your opinion that the clean water proposal violates Section 403.4129A of the Florida statutes, which was passed in 2020. I would also argue that it also violates 403.412, paragraph 2E, which basically says that a citizen can sue the government to, a citizen cannot sue the government when the government has issued a permit and the citizen is complying with that permit. And I would argue that this clean water proposal is contrary to that because it will allow a citizen to sue the Department of Environmental Protection after they've issued a permit and let's say a builder or a developer is complying with that permit. So I would also point out that that is an additional reason for the clean water proposal not to be lawful. That's all. Thank you.
Mr. Goodman, you want to respond to any of that?
Yeah, respectfully, with regard to the jurisdiction issue, I view that in a somewhat different way, and the reason that I view it differently is as follows. Article 5 of the Constitution was adopted by the people back in the mid-1970s, and it was the final piece of the Florida Constitution that was being put into effect to revise our Constitution, and our Constitution, of course, was completely rewritten and redone back in 1968. Up until that time, we had numerous different types of courts around the state. For example, some counties had what they call a criminal court of record. Other counties did not. We had justices of the peace which presided over a court in some counties. And I think what Article 5 was intended to do was to provide uniform jurisdiction throughout the state. In other words, whether you went to Hamilton County or Brevard County or Escambia County or Monroe County, you had the same court system, which is county court, circuit court, district court of appeal, and Supreme Court. And each of those courts, by legislative action, has prescribed jurisdiction, and it is, in fact, uniform statewide. So respectfully, you get two attorneys in one room, you're liable to get three opinions, the two attorneys' opinions and the right opinion. So, but I do respect your comments.
Are there questions? All right, well, thank you very much. We are now on the actual proposals themselves. As you know, we have had a series of votes on these different proposals. I think a total of 24 brought in. We have removed approximately 10 of those proposals to this point. So we are on proposal number 1, which will be, of course, the charter cap. Before I get there, we've had this ongoing discussion about when do we want to vote on these proposals. After today's hearing, we will have had officially 3 public hearings, meeting all the requirements as far as public notice, et cetera. I'm open to a discussion where you want to have the votes today on those that are kind of ready to go, or do we want to wait until the next meeting to have the final vote? Any opinions on those at this point?
Yes.
Mr. Tredice?
Yeah, I planned on making a motion to approve proposal number 1 after the discussion.
Okay. Other opinions? Mr. Mack?
I prefer we go ahead and vote on the ones that we can today.
Okay. Any objection to that? Okay, great. So after each proposal, we will have a vote. As we all know, in order to get to the ballot, it will take 10 votes. If a proposal falls short, it is thus eliminated from consideration, and we move forward. Of course, with our own ideas here, the goal of voting early, which I'm glad to see y'all are doing this, will give us the potential to look at this. Should there be any concerns, we can take a kind of another bite at that apple. But we'll have that vote accordingly today after we hear from public testimony on these mentions. Mr. Tredice, for a question.
Yeah, this is the third hearing.
Mm-hmm.
Probably the 5th that's actually, but it's the 3rd that's properly noticed on the proposal 1. So therefore, under the charter, it can be voted on. And if it's approved, it'll go to the Board of County Commissioners for the 3-attorney panel, so on and so forth. And that's why I said that I would make a motion for approval, because it's a third hearing, it's ready for it. But I disagree with your statement that we shall vote on every proposal, because the rules provide that any member can make a motion, and if someone wants to make a motion to withdraw from consideration a proposal, they're free to do that. But this commission did not just agree to vote on every proposal, and I really think that some of these proposals should be allowed to go to a third public hearing. And if someone wants to make a motion to withdraw them from consideration, they're free to do that. That's been done previously. But I think it's a wrong characterization to say that we've just agreed to vote on every proposal.
Well, thanks for that correction. All I would say is that as we've been discussing through this matter is if you're on the third strike right now, you're going to have that vote. And if you're not on that third hearing, we have had a series of votes, as we all know, to say whether to move forward or not. So we'll take a case-by-case basis. Obviously, on the first one, we had 5 hearings, and number 5, we've had 4, number 6, we've had 4. So we'll take it on a case-by-case basis. If there's a proposal that one of the sponsors want to withdraw, we'll take a look at that as well. Any other questions? All right, so let's move to proposal number 1. It is dealing with the charter cap. Mr. Tredis, if you want to remind people of this for the 5th time, you are welcome to do so.
Okay, I'll be brief, but since there should be a vote, I think, after it, I'll explain it again. This proposal would add language.
You might want to have the mic on it, or you get closer, one or the other.
This proposal would add language to the charter, which would make any increases beyond the charter cap 1 year in length only, and not become part of a baseline increase to the budget in perpetuity. It came as a result of a lawsuit by former Clerk of Court Scott Ellis in 2019 when that didn't happen, when the Board of County commissioned to exceed the charter cap, and it was not for 1 year. That tax increase beyond the charter cap became the baseline taxation for every year thereafter. Scott Ellis sued the board to try to prevent that from happening. That lawsuit was dismissed on procedural grounds, not substantive grounds. The 5th District Court of Appeal reversed that dismissal, and it's back in the circuit court as a pending lawsuit now. But the language of this proposal is actually taken from the briefs in that lawsuit, and it's actually the language offered by the county attorney explaining in the county attorney's opinion why the current language does not require the tax increase to be only 1 year. And the county attorney said if this language were included, then it would be 1 year only. So this language is directly from that lawsuit. It would make the 1 year increase just that 1 year. And I submit that that is what the voters intended by overwhelming majority when they passed this proposal. And the critical wording of the current charter is that, quote, the finding the finding of critical need. Quote, the finding shall set forth the ultimate facts upon which it is based and shall be valid for a single budget year, end quote. So the language is clear. I submit that the budget increase is to be only 1 year. That has not happened. This would correct what's been going on for years, and that is my proposal.
Thank you. All right, we do not have any appearance cards, so it's just us on this one. Is there debate on this issue?
Me.
Mr. Lubert, you're recognized, and I'll get you, of course.
I'll defer to you, Sue, if you'd like to go.
Thank you.
Please go ahead.
Well, I've spoken to this twice, I think. First meeting that we had, and why I believe it's not correct and why it should not be passed. Having been on the county commission and understanding what the budget is like, and what you go through, and if you have emergencies. And before I've used MSTUs for the Sheriff's Department. In fact, that is the reason that the commission did do that, because they had a severe problem with hiring and having deputies. And then, but if you also look at, Brevard is not unique. We happen to be a coastal county. We have hurricanes, we have tropical storms, we have flooding sometimes. And when you have that, occasionally, there may be a reason that you don't have any more reserve left in your county budget. Or if you do your reserve, then where do you get it from the next time? And then what Mr. Treatise wants to do is, when you have that problem that year, and if you have to go over the cap for some emergency reason, then the following year you have to revert to 2 years before that budget, which means all of a sudden you don't have that money. You don't have, and I don't know, I mean, I've lived in Brevard County for a long time because I'm really old, but it has had hurricanes. We've had storms. We've had emergencies in this county. And if you don't have the money to do that and the ability to deal with it, you're going to have a severe problem in this county. And I would ask you to please vote against it.
Sluger.
I'm like, there we go. Couple things. First, Sue, you took some of my talking points, so that saves me a little time. Thank you. As I look at this right now, at the end of the language where the new language is inserted, it basically stops with this. The findings shall set forth the ultimate facts upon which it is based and shall be valid for a single budget year. The language is already there. We've got a supermajority in place with the county commissioners to protect that. And then my other worry is, with all the things we look at, is legality. We've got an ongoing lawsuit. I'm not sure I want to be, or we want to be in a place where we're getting ahead of the lawsuit that's going to decide this anyways. So that's where I'm at.
Others in debate? Mr. Nye.
Yeah, I take the exact opposite approach. I think we exercise our authority here as this commission and resolve the issue so we don't have to rely on the courts. So I'm the exact opposite.
Mr. White.
I seem to recall that the specific action in question, that last ad valorem increase that was, the 4-vote majority that passed it on behalf of the sheriff, I seem to recall that the vast majority of the money he was requesting was for physical improvements. It was actually automobiles, and it was other kinds of equipment. These were theoretically one-time purchases. So the idea that you would keep that money as a new baseline going forward when it was spent for specifically what it was requested for, and that's not an ongoing need any farther, that's all the more compelling reason to suggest that Mr. Treatise is on the right track here, as well as is the lawsuit that's being provided.
Mr. Chairman.
And the language is clear.
Ms. Schmidt.
When you're talking about the sheriff, you're talking about the MSTUs. And there was litigation many years ago that caused MSTUs for law enforcement. The MSTUs are for the unincorporated area only, because before that, all the cities were also being charged the same amount of money for those deputies, and they were only doing their road patrol in the unincorporated area. So when you're talking about the MSTU, you're also talking about salaries, not just equipment.
That was not what I was talking about at all. I was talking about the sheriff's very specific proposal. The reason that he came to the county commission was because he needed X number of automobiles and he needed X number of radios. It was all specifically physical equipment. It was a one-time purchase. It had nothing to do with salaries or anything else, as I recall. So my question becomes then, why in the world would you let that amount of money for those specific physical plant kinds of purchases become part of the new baseline going forward? It makes no sense to me. That's all I'm saying.
It wasn't for all of the equipment, but I'll leave it go at that.
Others in debate?
Go ahead. I'll defer to
Mr.
you, please.
Treatise, you're recognized.
Yeah, I just wanted to point out that it's true that if this proposal passes, it'll end the lawsuit. It won't confuse the lawsuit, it'll end the lawsuit, because this ends the lawsuit. It's clear now. And a hurricane, I submit, is a perfect example of a one-year increase. Here, you have expenses from a hurricane. Well, you don't have those hurricane expenses the next year. And it's true, and it's in the materials, the finding of critical need that was made for a few years ago for law enforcement. It had specified all the dollar amounts for repairing buildings and roofs and tasers and cars. And the items were all added up in a dollar, and there was no dollar amount for salaries in that request of the sheriff. It was for physical things. That's all.
All right, others. Mr. Fisher.
I won't be supporting it, and this is why. I think we're the only county in the state that has to live under this charter cap rule. When, at the time you look at the history of Brevard County compared to other counties, has been an efficient operation, do things well, rank one of the highest county as far as providing services and tax being low. So strapping this county with this, I think it's unfair, and I think I think Mr. White's wrong. I think a lot of that need for the sheriff was for people, and I think once you start adding people and salaries, it's hard to take it back and make that up. So I won't be supporting it.
All right, there's the debate. Mr. Lubiker.
Yes, sir. Thank you, Mr. Chair. If I may, Bob, I just want to kind of clarify a little bit about what the sheriff asked for, because I was part of those meetings. Okay. And yes, a lot of it was equipment-based. However, I think you have to put this in the perspective of where we are current times. His argument to us, or to the meeting I was in, was the growth that we're seeing in the county and trying to keep up with that with modernized equipment. It was Narcan units for folks that are ODing, which is on the rise in this county. So going back 2 years in time to that budget, when we see the growth of the county going this way, population, and then combine that with what we're seeing in this economic environment, I don't think that we can realistically say there's not going to be more ask like this. We're going to have to take care of public safety. It's core job one of public service at the local municipal level. And so, again, I think the current language is correct, and I'll leave it at that.
Mr. Chairman? Seems to me if you think the current language is correct, you'd want to support this proposal. Because what this proposal does is it basically reiterates the current language that's in the charter, where it says that,
You want to speak?
in a sense, you know, you literally, well, you know what I'm trying to say. And I think the other thing, too, to Mr. Fisher's point, is that it may very well be that we're as efficient a county as we are because there is this cap that's in place. And commissioners know it, and budget directors know it, and county chairs, division chairs know it, and so they have to work harder. And I don't see a thing in the world wrong with that. I'm glad we're as efficient as we are, and I think that this proposal probably has, or this rule probably has something to do with it.
And we were efficient before the rule came in.
Well, that's fine, too.
We
We're just comparing apples to apples right now.
Thank you, Mr. White. We have a Janice Crisp who wants to speak on it. We'll allocate a couple minutes to her. Welcome.
Thank you, sir. I was here when the sheriff came and asked for more money, and it was indeed for one-time equipment. And I would just like to say I agree with this charter cap because I don't believe we've had an audit on the sheriff's budget when he is spending hundreds of thousands, I think maybe $250,000 or more producing YouTube videos, which is absolutely inappropriate when we're talking about this. And he came and asked for that money, and again, he's going to come and ask for more. And he refuses to give a line item budget for his department. When we haven't even asked him for that, that should be something he gives immediately. And when we're talking about the money for taxpayers, and we're discussing this, we haven't had an audit for our school board. When the superintendent himself got really irate with the public when they asked for it. This is something that has to be considered in this review and forced by the county commission because they oversee them. There's a lot of departments under the commission's departments, the rule, that need to be, have an audit and find out where this money's going. Because here we are talking about money, taxpayer money, and you're debating it like it's monopoly money. This is our money, and you need to take care of it a lot better than this. We don't need to be making YouTube videos for the sheriff.
Mr. Chairman.
Ms. Schmidt, you're recognized.
Yeah, I wanted to ask Mr. Leisenfeld a question. I'm sure you're thrilled. But are there not audits being done of all departments and all constitutional officers?
I can't tell you the constitutional offices for sure, but they're departments of the county audits. There's an audit plan that goes through each department regularly, that we get scheduled for. So, and the commissioners approve the plan and the audits for the next year.
Thank you.
All right, Ms. Tredis, you ready? I don't think there's anyone else to speak, so you're recognized to close on this proposal.
Okay. I'd like to point out that the people who have spoken against the proposal are basically arguing that they don't like the cap. We have needs that need to be met, but they're not arguing that the intent of the voters in passing this was not clear, that this only be for 1 year. So if you disagree, and if you disagreed with the charter cap, then I ask, why didn't you make a proposal to repeal it? But instead, the people who are against the proposal just want to go on this continuous year after year of violating it and just ignoring it, knowing that this is not what the voters voted for, which I submit is just wrong. If you don't like it, you should try to change it, and no one did that. And as far as Brevard County having the only charter cap like this in the state of Florida, I submit that's not true, because if a single year critical need becomes part of the baseline budget, then there is no charter cap. It's on paper only. In practice, there is not one. So I'd ask you to vote for this proposal. Thank you.
All right, we've now concluded the 3 public hearings. This will be our first vote on the measures. As you all know, there's 10 votes required to send this along. And so without any objection, we'll have Melissa call the roll. And if you are for the proposal, vote yes. If you're against the proposal, of course, vote no. Melissa?
Robin Fisher,
No.
Kendall Moore,
No.
Marcia Newell,
No.
Marie Rogerson,
Yes.
Blaise Tredis. Bob White,
Yes.
Matt Nye,
Yes.
Gabriel Jacobs Kirstein,
Yes.
Jenkins is absent, Cole Oliver,
No.
Sue Schmidt,
No.
Jordan Chandler,
No.
Vic Luker,
No.
Dave Newman,
No.
Chairman Herodopoulos.
Yes. All right, by your vote, the proposal fails. All right. We are now on number 5, also by Mr. Tredis. We have now concluded 3 public hearings on this as well, and so after the debate, we'll have a up or down vote on proposal number 5 as well. Mr. Tredis, you're recognized.
Thank you, Mr. Chair. This proposal this proposal would provide this additional sentence to Section 7.4.1, independent review of proposed charter amendments. Quote, if at least 2 members of the panel find that the proposed amendment is not consistent with the Florida Constitution, general law, or this charter, then the proposal is considered rejected and is returned to the County Commission or to the Charter Review Commission for further action, if any, is to be done, end quote. This is the I call it the 3-attorney review panel. And as it's written, if 2 members of the panel find that a proposal consistent with the Florida Constitution, then the Board of County Commissioners shall forward it to the Supervisor of Elections to be placed on the ballot. What is uncertain and unknown is what happens if, say, 2 members of the panel say that it's not consistent with the Florida Constitution. As it's written, the County Commission could decide, well, we want it on the ballot because we like it, or we don't like it so we won't put it on the ballot. So this solves that problem. And I think that it's really necessary. And I know in the past that I argued against the 3-attorney panel because I just originally was against the idea of lawyers having that type of authority, really. However, what happened with the clean water proposal in Orange County really made me change my mind on this. And what happened in Orange County was that in July of 2019, their Charter Review Commission, apparently, I know, and I'm stating these facts from reading a lawsuit in Orange County that's pending now on the clean water proposal. So I think these facts are correct. There were very expensive, very good lawyers involved. But in Orange County, it appears that the Charter Review Commission actually serves 4-year terms, and on any general election ballot can place charter proposals. So in 2019, early 2019, like in July, a committee was formed of 3 attorneys, an engineer, and a biologist to come up with a right to clean water proposal. So they worked on it, and they finished their work in January 2020. The legislature in 2019 came up with this bill, which in part includes the part that's been discussed already, which basically says charters cannot pass a charter amendment that provides that a body of water has a right to a lawsuit, or a person can sue on behalf of a body of water. So the legislature, at the same time the Orange County Commission was coming up with this clean water proposal, was having legislative hearings on a bill which would specifically prohibit Orange County from doing that. And it's interesting that in March, the Orange County Charter Review Commission voted approval of the clean water proposal just days later. Because the bill was already on the floor going through its multiple readings, the legislature passed its law saying you cannot do this specifically. So what it really emphasized to me and made really clear was that charter review commissions, they don't have to follow the law. They could knowingly pass a proposal which they know violates the law, is contrary to the law, and that's what was done in Orange County. And it really made me think that even though I don't like lawyers having this authority, I really think it's a necessary backstop or emergency brake for a clearly unconstitutional or unlawful charter proposal to be withdrawn. Under my proposal, it's not a final thing because the proposal goes back to the Charter Commission or to the County Commission. So if they want to rework it or retry, and they can do that. So it's not a final thing. But I really think that it's important that that there be some procedure in place to prevent clearly unconstitutional proposals that violate or are contrary to Florida law, that they not go on the ballot. And that's why I amended the proposal the way I did. And I think it's necessary, and I'd ask you to vote in support of it. Thank you.
Thank you. Other questions for the sponsor of this proposal? All right, there are no questions. Any debate?
I would ask our county attorney.
Sure, please go ahead.
Charter Commission attorney. I know of no other incidents where 2 out of 5 commissioners get to move something forward one way or the other. In this case, we only got 4 commissioners now, so it'd be half of them, 2 out of 4. Do you know of that ever happening or being allowed?
No, not off the top of my head.
Okay.
But I don't think that's necessarily the situation that you've got here. I mean, you're talking about a panel of 3 attorneys, and rather than county commissioners, and their charge is much different from that of a county commissioner. Their charge is to look at it from a standpoint of whether or not it is consistent with the Constitution and consistent with the law. County commissioners have a much greater panoply of considerations in whether they move something forward or deny something.
Yeah, but I mean, isn't Mr. Blaze asking that 2 of the 5 commissioners send it back? Is that what the proposal is?
No.
Am I misunderstanding
No, no.
something? Okay, help me understand that.
No, basically what happens is if the attorney review panel does not find that the Charter Commission approved proposal is consistent with the general law or consistent with the Constitution, they deny it, then it gets returned to the County Commission or to the Charter Commission for further action or no action, as the case may be.
So if
And
it
that's,
goes,
what I think his proposal is doing is it's basically correcting a glitch that currently exists in the charter. Because the charter talks about if something is found by the attorney review panel to be consistent with the law, then it moves forward to the ballot. Well, what the charter does not say is if they don't find it consistent, what happens? Does it just go nowhere? Does it get returned to the county commission? What happens? So,
So you
the only
recommend-
thing I will tell you is that probably in most cases, if the attorney review panel finds that the proposal is not consistent with the law, it says, the language says that it be returned to the county commission or the charter commission. It's probably going to end up being returned to the county commission, because usually the charter review commission does not complete action until near the end of its tenure. So the proposal's probably going to go back to the county commissioners.
so if it goes back to the county commissioners, how many county commissioners do you need to act on it? 2 or 3?
Two will not do it.
So you need
You need a
majority of the county commission.
Yeah.
You actually need 4,
Yeah.
supermajority.
Supermajority. Okay. So you recommend we approve this?
I think you should, because I think it is a clarification of existing law.
Okay.
It plugs a hole.
All right, seeing, I'm sorry, Mr. Knight, of
Just a
course.
quick comment for the record. So I understand your concern, but I think, to me, the probability of the commissioners, like you say, the attorneys acting, to quash something, perhaps on behalf of the commissioners, that seems far more likely to me than a commission like this going rogue and intentionally, passing something that's unconstitutional. So I just wanted to be on the record with that piece, but I'll support it as amended.
All right, seeing no other debate, Melissa, why don't you head and call the roll?
Robin Fisher,
Yes.
Kendall Moore,
Yes.
Marcia Newell,
Yes.
Marie Rogerson,
Yes.
Blaze Tredice,
Yes.
Bob White,
Yes.
Matt Nye,
Yes.
Gabriel Jacobs Kirstein,
Yes.
Cole Oliver,
Yes.
Sue Schmidt, Jordan Chandler,
Yes.
Vic Lupker,
Yes.
and Dave Newman,
Yes.
and Mike Paradopoulos.
Yes, and by your vote, the proposal passes.
Wow. Unanimous.
Okay, we move now to proposal number 6 on clean water. We have some series of appearance cards for that, so why don't we start working on those? We'll allocate 3 minutes to each person who'd like to speak on the issue. And of course, if members of the commission would like to ask questions of the presenters, you are welcome to do so.
Mr. Chairman?
Yes.
If I could ask a procedural question
Sure.
before we get into Proposal 6. Under your rules, at this point, you have approved Proposal number 5, and I assume what you want is for that to be brought back to you at one of your following meetings, so you can approve the ballot language and resolution to go on the ballot.
That's correct.
Thank you.
May I add that Mr. Googleman is going to write that pursuant to our rule change and the rules of procedure. Thank you.
All right, the first person we have for proposal number 6 for Right to Clean Water is Thomas Altiff. And Lori Thompson will be next. All right. Laura Lee Thompson, I'm sorry.
Good afternoon. My name is Tom Altiff. I'm at 3405 South Washington Avenue, Titusville. I grew up in East Orange County, and I've been fishing the Indian River Lagoon since I was 8 years old. So I've seen all the changes that have come to the lagoon. I own and operate one of the largest kayak stores on the east coast of Florida. And my business, as well as many other businesses, I'm approaching this from an economic point of view, is dependent upon the Indian River Lagoon and clean water. From my point of view and from talking to other businesses, the restaurants, hotels, retail stores, retirees that move here, our winter visitors that come down here, all of them are drawn to Brevard County because of the water. And that's what makes us so unique. We have one of the most unique estuaries in the world, and we need to protect it. We also have a large recreational fishing industry, and at one time we had a very significant commercial fishing industry. If we have clean water, we will always have an economic engine to depend on. Clean water is the key ingredient. My customers, most recently even, have been asking me, is it safe to kayak on the Indian River Lagoon? What is the odor coming off the water? What happens if I turn my kayak over and I'm in the water? Is it safe to swim in the water? And then some of them will tell me, okay, after I answer the questions, well, I'm going to take an alternative course. I'm going to go to one of the spring runs. I'm going to go to a lake that I know is clean and I know is safe. I want to add one other thing. My children have often told both myself and my wife that their best childhood memories are days they spent as a family on the lagoon, catching fish, catching crabs, and swimming in the water. My love of fishing in the lagoon actually resulted in me skipping school in my senior year of high school. Sure. And because I skipped so much school and came over here, I didn't meet the days in school qualification to graduate. So I had to go to summer school. And I did that, and I got my diploma, and then I went on and graduated from Rollins College.
Well, we appreciate you coming in. Any questions? Thanks for taking the time to visit with us. Thank you, sir.
Thank you.
Laura Lee Thompson, followed by Naira Atia. Okay, Atia, okay. Naya, sorry. Laura Lee, welcome back.
Hi. Thanks for letting me speak. I'm Laura Lee Thompson, 3550 Irwin Avenue, Mims. I love visiting restaurants when I'm in Washington, D.C., where I'm handed a wine list and an oyster list. Tantalizing write-ups reveal the source of the oysters, the size of the oysters, and how each one tastes. I can order a mixture of oysters so that I can savor and compare every one. With more estuaries and miles of coastline than any other state except Alaska, Florida should be the most diverse producer of oysters. That's the way it was when I was a kid. Every Florida estuary had its own local oyster. Their distinct sizes, shapes, shell colors, and tastes were instantly recognizable to oyster connoisseurs. With the Apalachicola Bay oyster industry declared a federal fisheries disaster, we've lost the last commercially available Florida oysters. How embarrassing is it that Florida restaurateurs don't even have one type of Florida oyster to serve to our guests? Oysters are just one example of how Florida's declining water quality is impacting vital commercial and recreational fisheries. In a Hail Mary attempt to keep a fishery alive, the most recent blow landed directly on Brevard County last month when FWC commissioners voted to designate the Indian River Lagoon as catch and release only for redfish. Now, I've already explained to you guys how devastating the loss of our standing as the redfish capital of the world has been on our recreational businesses. Going after fishermen is not the answer. The solution is to stop the sources of pollution that destroy our waterways. The sad and dangerous condition of Florida's estuaries, nearshore waters, lakes, rivers, and springs threatens our drinking water, tourism, real estate values, the ability to attract new industry and employees, and most of all, our quality of life. We've done everything that you guys asked us to do to simplify the language of the Right to Clean Water addition to Brevard County's charter. Unless new issues are raised today, we've addressed every concern that's been brought forth. The right to clean water is not aimed at Brevard County or its municipal governments. It is not pointed at private businesses. The target is Florida's state agencies when they fail to enforce their own policies to safeguard our waters. Brevard County has an opportunity to lead the charge in this movement to make state agencies responsible for protecting our waters. Your decision for Space Coast residents today is simple. Will you allow Brevard County voters to choose to be a state leader, or continue to be a toilet for the rest of the state? Thank you.
Thank you. All right, next, Naya, followed by Thomas Perez.
Good afternoon, honorable commissioners.
Nice to see you.
Thank you. Naira Atiyah, Beechwood Court, Titusville. Driving across the Max Brewer Bridge a few days ago, I saw a gaggle of children playing in the lagoon, splashing happily as they floated in their brightly colored inner tubes. When their laughter reached my ears, it filled me with wonder. I began to experience their joy when suddenly my heart skipped a beat. What would be the consequences of these kids' few hours of fun and frolic in the waters of the IRL as their mother looked on, doubtlessly unaware of any danger? Would they end up like the manatees, gentle creatures, lost to us as a result of neglect, ignorance, mindless disrespect of one of our life's lines, clean waters? An open wound, a scratch exposed to the feces, fertilizers, and toxins desecrating the Indian River Lagoon could be fatal, as it nearly was for me in 2006, when I swam in this very lagoon, now doubly polluted. I was staying at the then Holiday Inn when I fell ill. I will never forget the room service oatmeal left at my door, nor the bunches of bananas my son ordered, the only foods that I could tolerate. No one dared come near me as meningitis was suspected. For days I ran a fever of 104, trembled, sweated, and could only crawl to the bathroom to throw up. 3 incorrect diagnoses later, and 2 weeks isolated, quarantined in my hotel room, I was just steady enough to fly home to Utah, where I lived at the time. My doctor sent me to an epidemiologist who immediately put me in hospital, followed by a long course of intravenously administered antibiotics as an outpatient. Swimming in the IRL, I had contracted a deadly bacterial blood infection, which laid me so low that I could hardly move from the sofa where I languished for 3 full months. My heart remains damaged. Water is a healer. Water is sacred. We baptize in water. My ancient Egyptian ancestor did so. May I have a little extra time?
Sure.
My ancient Egyptian ancestors did so thousands of years ago. We drink water. We wash in water and with water. We cannot survive without it. And if it becomes deadly, what shall we do? We have allowed our jewel, the Indian River Lagoon, to be subsumed in filth, desecrating the very body upon which depends our well-being, and that of all sentient beings. We have fouled our nest. Don't you think that there may still be just enough time to undertake the sacred duty we have to clean and restore our lagoon to its rightful magnificence and to our benefit and that of generations going forward? Today, the choice to put the Right to Clean Water Amendment on the ballot for the 2022 election is in your hands. We are here to respectfully request that you make the decision which will etch your names on history's ledgers for having done the right thing and for having preserved a healthy environment for your descendants and ours. A beloved American poet once wrote, and I quote, "We can count on so few people to go that hard way with us. We can count on so few people to go that hard way with us. May we count on you for being among the few. You have kindly lent us your ear. Now, won't you please lend us your vote? Thank you, and thank you for your service."
Thank you so much for your time.
Thank you.
Mr. Perez, followed by Maureen Roop.
Good afternoon. My name's Tom Perez. I live in 3025 South Washington Avenue in Titusville. I'm a retired pharmacist and epidemiologist from the U.S. Public Health Service with 30 years of service. I also have a master's in public health. Thank you for your service and consideration of the various proposed revisions to our Brevard Charter. I support the inclusion of the right to clean and healthy water in our charter. Here's an example of how it might be used. We probably all remember back in spring 2018, we started hearing that Blue Cypress Lake was experiencing algae bloom. The blue-green algae grew and grew until we had a serious health situation on the Class 1 headwaters of the St. John River, the source of our drinking water in Lake Washington. By the way, we no longer have Class 1 waters in the entire state. TC Palm and other media were covering the problem and even traced it directly to the excessive dumping of partially treated human waste known as biosolids on the Presley Ranch. It took months for the DEP to investigate and finally to act in its July 12th letter, halting the dumping. DEP reported that microcystin levels in the lake were found to be at 4,700 parts per billion, more than 47,000% above the 10 part per billion toxic limit. Their action was good, but very late, and after much damage was done. Dumping of some 5,000 dry tons per year of dry poop began in 2012, after the legislature prohibited this dumping in South Florida. Indian River County disposed of their waste in landfills, but we in Brevard were inundated by tons and tons of human poop from South Florida for years. H&H Liquid Sludge Disposal was paid over $1 million in 2017 to dump 5,277 tons on the Presley Ranch adjacent to the lake. Observers had reported that water was pooling in the dumped material months before the algal bloom began. We knew our very drinking water was being contaminated, but there was no path to address the growing issue. A legalized harm was underway. Withstanding to seek equitable relief under this provision, the observer of the pooling water or someone seeing the endless stream of trucks full of poop could have raised this issue, could have protected our drinking water before it became toxic. Brevard now has the opportunity to include the rights to clean and healthy water. Just finishing a sentence.
Sure.
Okay. To include the rights to clean and healthy water in our charter and be the proud leader of our state or be the state's toilet. Thank you.
Thank you, Mr. Perez. Ms. Roop, followed by Bill DeBusk.
Maureen Roop, Port St. John. Since 1998, I have been on 3 charter reviews. The last was in 2015, and Commissioner Fisher appointed me. And 4 members on this review now were on that same 2015. And I don't know whether they remember, but I brought forward an amendment to ballot for Brevard County, the right of Brevard citizens to clean air and water, as well as lands free of pollutants, is not addressed in the current charter. The water in Brevard County is so degraded, our economy and quality of life is threatened. The current system is not working. For just an example, there is an effort to replace septic with sewer, which is good. But biosolids from sewers are spread on the land. And in Port St. John, it's yards from the school, and you can smell it from the school, and it all along the west side. And there is technology that will turn biosolids into energy. They do this in Europe, and the Gates Foundation in South Africa also does it. Reuse water. That contains nitrogen and phosphorus, and that is used extensively throughout the county, like it's doing no harm. There are a lot of examples why we have to change, and if we fail to do so now, you know, I always think of something my science master said when I was at school. And he said, I don't know if it's true or not, but it's worth thinking about. And he said, you cannot manufacture water. It is the same water the cavemen drank. Thank you.
Thank you very much. Bill DeBusk, followed by Melissa Martin. Welcome.
Hey, good afternoon. My name is Bill DeBusk. I live in West Melbourne. The right to clean water, according to an attorney that I respect, already exists by statute in the state of Florida. Although this statute exists, it concedes way too much authority to state agencies like FDP to protect our waters. The current process for protecting our water is highly dysfunctional. Proof of the dysfunction frequently makes national news, with constant harmful algae blooms, mass death of fish and wildlife, and public notices of pathogenic or toxic contamination of our waters. This is not okay. People suffer, wildlife suffers, property values suffer, businesses suffer, and communities suffer. Brevard County suffers because of these ineffective, dysfunctional processes. Adding the right to clean water to our charter will inform our citizens that they have the right to ask a judge to review evidence and decide on how to stop or remedy pollution that impacts our Brevard County waters. The Right to Clean Water Amendment will support the basic principles that people, not the government, are the best stewards for our natural resources. Waiting for political solutions in a system that favors actually big money from polluting industries is not the right thing to do. We need a clear, simple, legal solution to restore the necessary checks and balances to protect our waters, because our water is critical and necessary to all our lives. We need, in the Brevard County Charter, the right to clean water. Thank you for your time.
Thank you, Mr. Buss. All right, next we have Melissa Martin, followed by Tony Schifalo. Welcome.
Good afternoon. My name is Melissa Martin. I live in Eugene, Oregon. Used to live here, and actually I still have ties to Brevard. We are property owners in Canaveral Groves, and then you have the nostalgic factor of meeting my husband here, dating here, you know, raising kids here for a little while. But the fact is that we intended to live and die here. This was supposed to be our retirement plan. You know, things change, life changes, and much like systems change, economic systems change, environmental systems change, legal and governmental systems change, and the primary reason we are here today is because that our current system of water protection has been lagging behind and has failed to keep up with life changes. And we can all see and smell the results. When you're talking about amending charters or constitutions, it's obviously a serious matter. These types of measures have long-term effects. So the guardians of the amendment process, which are you, must be slow to change. It must be a deliberate review, sober to all foreseeable consequences, and only entertaining proposals that would clearly fulfill your mission, quote, for the most common benefits to all our inhabitants. Proposal 6 meets these requirements. Funny enough, it's one of those rare issues that immediately reach across party lines and unite Floridians as Floridians. This is an issue of good stewardship, being fiscally conservative, ensuring good government, and protecting individual and business rights and economic interests from the harmful activities of others. The bottom line to this all is that this is a choice. Should Brevard County take advantage of this opportunity, or should it stick with status quo and the water problems that come with it? When you ask what Brevard should be known for, should it be known for being a state leader, or as you heard, the state toilet? And we're using that analogy because of the alarming statistic that we heard that regarding biosolid applications, a very high percentage of the entire state of Florida's poop is coming to the St. Johns River Water Management District. A very high percentage. And that's your home now. So is that something that you want to be known for? And in the big picture, who should pay for the costs of water pollution, the polluters or the taxpayers? In the end, it should be up to the voters of Brevard County. They're the ones who should choose which path to take and what type of future they want. I appreciate your consideration of this proposal, and I stand by to answer your questions.
Perfect timing. All right, seeing no questions. Sorry, Mr. White for a question.
Are you the Melissa Martin that sent us the email earlier today?
Yes, sir.
Okay, so you are an attorney?
Mm-hmm.
Okay, all right, so, and you're familiar then with a lot of the
Issues.
legal issues and procedures and those kinds of things. So, and it was brought up earlier, one of the other speakers mentioned that this is not an attack against homeowners or businesses or anything like that. This is directed specifically at state agencies. Can you speak to that?
Absolutely. To distinguish this from the Orange County Charter, it's absolutely nothing, well, okay, there's a little bit of overlap, but it's not designed from the Orange County Charter. The Orange County Charter was looking at the rights of waters and the rights of people to, sue on behalf of the waters and things like that. This is a purely like a human right to clean waters, which is defined in the proposal. But another distinguishing factor is that we're only facing the issues of state agency activities in action or in inaction regarding their decisions that end up harming the water, that we're supposed to depend on them for protecting. So it's just a state agency, executive branch state agency issue, because the buck stops there. Even when you're talking about polluters in the corporate context or whatnot, they still they undertake their activities pursuant to a permit that the state provides or approves. So that's why this is only focused there.
Can you give us some examples of various state agencies that may have failed us in the past with regards to what's been happening with the lagoon and other state waters? Not necessarily here in Brevard, but everywhere.
Sure, absolutely. How much time do we have?
It's a question. She gets
Sure.
to answer my question, right?
I think that the quickest and easiest and most compelling example is the fact that the biosolids application issue of the fact that it's not regulated well, but it's in practice right now. That's a matter of inaction, perhaps, from the state's point of view, where biosolids are absolutely being applied in very inappropriate areas, where it goes right into the water systems, the superficial aquifers for drinking supplies. That's an example. So either they give a permit to allow that would be an action, or allow it without any regulations in place, that would be a policy of inaction. But both ways, it's the state's fault.
Okay.
I do have a quick question as well. One of the points that's pointed out in the memo from the commission's attorney is that standing is not really addressed. So, it's clear what you guys are trying to do based on your explanations, but when this is either litigated or looked at from that perspective later down the road, do you guys have a problem as a group with addressing standing, and how do you look at that issue now?
Sure. Standing is more or less, the gatekeepers are the courts, right? Whether or not you provide enough standing. They're more or less there to ensure that, they hear cases or controversies where something is going on that affects the plaintiff, their zone of interest.
I'm a lawyer, I understand
Okay,
standing.
good.
My question is, you guys don't address who has standing.
Mhm.
So who has standing and who doesn't in this?
Well, the fact that I believe it's laid out for residents and businesses and local governments, or just organizations that operate in the county, provide a nexus for the zone of interest going on. There's a safe presumption that how the lagoon goes, for example, so goes Brevard County interests on a very wide scale. Taxes, the whole 9 yards. So did I answer your question?
Sure, yes, but would you also, I guess the main issue is that would you guys put something in there specifically addressing who has standing, so you're not just leaving it open to interpretation? Is that something you would consider as a group?
I'll consider anything to get this passed, but I think that the fact that it's laid out as residents and businesses and organizations that operate in, I think that's a safe condition for the plaintiff to bring in his or her complaint.
Right.
I am a resident of Brevard, therefore I have interest in standing on this issue. They could probably go further with that. My land is next to this water and it's in direct threat, whatever. So that the more you can attach that type of connection, the greater chance that the court's going to find standing. But there's the fact that it's not detailed in the sense that it's you need personal injury or your personal property is at stake is a different matter. We intentionally created a zone of interest based standing issue.
Okay, thank you.
Other question? I think Mr. Tredis was next, followed by Mr. Lupker, and then Mr. Winai.
Ms. Martin, thank you for replying to my email for the case name and number of the Orange County lawsuit. That was very helpful. And also want to, thank your group for being very forthright in all the written materials. I think you've pretty much laid out the pertinent statutes, even when they're against you. But I wanted to ask you this. This proposal of yours, if it were to pass, let's say there is someone who wants to build or is going to build a subdivision, and that developer, the owner, gets all the permits that are required from every state agency that has to issue a permit, let's say the Department of Environmental Protection. And they get those permits, they spend a lot of money and time to get those permits, and they're ready to proceed. And then wouldn't, under your proposal, a person could then file a lawsuit under this proposal to stop that project from continuing, arguing that under this proposal, under this new charter provision, that it harms water?
Only if there's proof that the permit will harm water.
Okay, but the point I'm making is the developer, the owner, has gotten all the permits they need to proceed, and they are proceeding in accordance with those permits.
Right.
Which takes me to 403.412, Section 2E, which says, quote, "No action pursuant to this section may be maintained if the person, natural or corporate, or governmental agency or authority charged with pollution, impairment, or destruction of the air, water, or other natural resources of the state is acting or conducting operations pursuant to currently valid permit or certificate covering such operations issued by the appropriate government authorities or agencies and is complying with the requirements of said permits or certificates," end quote. So this law says that if you've gone through all the steps to get permits and you've gotten them and you're complying with the permits, you can't bring a lawsuit against. Isn't that the way you read this Florida statute?
No, and I thought we had clarified that in email, but if you reread the first 5 or 6 words of 2E, please.
No action pursuant to this section may be
So
maintained.
pursuant to this section is the clause that I had pointed out. This is a separate cause of action, which Brevard County does have the authority to create and enforce. So it wouldn't be, that condition within that statute has no bearing on this particular cause of action.
When you say, though, that the legislative intent is perfectly clear, that a person who has gone through all the steps they need to do to get permits from the state, they've gotten them, they're ready to proceed, that the legislative intent is that they need to be able to proceed without interference from the courts because they've done what they need to do.
Well, the legislative intent is also very clear about abating water pollution. So how the agency interprets that, where it interprets it, whether or not it's uniform across the state or whatnot is a totally different issue. And we're saying for the purpose of the interests of Brevard County residents and businesses, the interpretation should fall back on the legislative guidance and clear policy, constitutional policy for water pollution abatement.
Okay. Well, Chapter 2020-150, you're familiar with that because that's been going back and forth, and that was actually what enacted 403.412.9A, and that was basically, I think, the most important reason why the commission attorney found that this proposal is contrary to state law. And I've already given my history from reading the lawsuit that was spelled out, but let me just read you a quote from there. I'm going to skip the part on giving rights in court to an animal or a body of water, because I know your proposal bypassed that, which Orange County didn't. There's that lawsuit was filed in the name of, swamps and bogs and whatnot, and you avoided that. But let me read this part. Quote, "A local government regulation, ordinance, code rule, comprehensive plan, charter, or any other provision of law may not recognize or grant any legal right or grant such person or political subdivision any specific rights relating to the natural environment not otherwise authorized in general law or specifically granted in the state constitution." So isn't your proposal granting people and political subdivisions rights which are not in currently the Florida statute or the Constitution?
No, and I'm not sure if you would like me to bring up the email conversation we've had and just reread what I've written, but there are a few important parts to point out. One is that I believe a previous speaker had mentioned that, yes, we do have the right to clean water. We actually have the right to clean environment as interpreted by the Florida Supreme Court. And you're welcome to speak up and, like, chime in wherever you would like. But the fact that is, we can't enforce it is the issue. So as we had mentioned in our back and forth, there are two different rights that are at play here. One is the inherent kind of fundamental right that residents have to a healthy environment around them, right? And the other is more of a substantive law type of enforcement measure right, the capability or the ability to ensure that is protected, that right is protected. So with the ambiguity of the preemption language, we're not really sure what right they're referring to, but as I explained, either definition that you take leads you to the conclusion that this proposal is outside or has sidestepped that intent. Whether they intended, we don't have the right to a clean environment. I'm sorry, go ahead if you want.
Okay, let's keep on going. Ms. Lewicker, go ahead.
Melissa, again, welcome back to the East Coast, as I said before the meeting, and I hope you have a great time here in Brevard.
Thank you, Vic.
Before I ask a couple questions, can I clarify, are you here as an advocate? Because I know how important this is for you. Are you here in an official legal capacity?
No, I'm not a retained attorney. I'm just someone who loves clean water in Florida.
You're very passionate about the issues, no doubt about it.
Yeah.
Let
I'm also
me ask you
working pro
this,
bono, if that matters.
You just alluded to this, and I'm curious because I wrote this down. What state statute is this addressed in already that the Supreme Court has upheld, Florida State Supreme Court has upheld?
Sure. It's a statute called the Environmental Protection Act, and it's the 403.412. That's the primary statute. I think it was in the 70s or something they enacted it, and with the express purpose of trying to implement the constitutional guidance found in Article 2, Section 7, regarding, and it talks about water pollution abatement and conserving natural resources. So that, and the Florida Supreme Court had found that state statute implemented that guidance and created a substantive law, a substantive right that the Floridians didn't have before. So before, they didn't have the ability to enforce their right to clean water. After the statute was enacted, they have the ability to enforce their right to clean water or clean environment. How that right, the ability right, has been degraded is found within the state agencies. How they have more or less not fully, they're not fully performing the intent, the legislative and constitutional intent and guidance that they were given. So they're creating their own legislation within the agency to a degree. And
Government
also,
agencies have a tendency to do that.
They can do that. There's also an issue of administrative hearings. So you have all three branches of government type of functions within the agency, and this helps to pull out some of that to ensure that everything's on the up and up. And if it is, there's no grounds to bring cause of action. If there's something to talk about, there's something to talk about. And again, the court is there to rule in equity. So that it's not a monetary damages thing against the state agency. It's within their mandamus power of like looking at is the government official or the government entity doing their job according to the law, constitutional legislated law. No, then fix it.
Okay, and that brings up my follow-up question. I'm glad you kind of led into it, cause of action.
Mm-hmm.
Could someone not now sue based on cause of action if harm has been done and evidence is there to support it?
No, because there's an exception to the current EPA, the current statute, the enforcement statute, that says if there's something permitted, then, it's fine. We're saying, even though it's permitted, let's look at it anyway.
Okay, well, thank you for answering my questions, and again,
Absolutely.
welcome back.
Thank you.
Mr. Denali for a question.
Actually, I think all of mine have been answered in this dialogue. So, yeah, thank you very much. This is, you're very articulate. It's very, very interesting. I think my biggest concern revolves around the, unintended consequences for the private property, and then through no fault of their own, they end up being a defendant in a lawsuit or something along those lines. So that's my biggest area for concern.
And that's, so there's like the issue of, the voters vote this in November, right, this November, a current or pending permit or a, permit that's in existence that's about to be fulfilled or whatever could technically be brought in. That, I'm saying a bad permit, not just any permit, but a clearly harmful to Brevard waters permit. That could be brought in and under like an injunction type of lawsuit, an ask, and reviewed for all of the considerations in place, the interest, the fairness aspect, if the plaintiff is bringing something frivolous versus there's an actual on the merits issue here that is going to have major consequences versus so it's going to be all considered, and the court in equity will rule based on practicality, interests at play, but still maintain an eye to the fact that Brevardians have a right to clean water.
Well, but to be clear, though, you just said even if something was permanent, like that's my concern, is you said even if something's permanent, you're still going to take a look. So to me, that seems like the door is always open in that private property owner.
That's the thing. If, that's the snapshot, that's a temporary window of time. However long it takes for the state to catch up with what this is the window that is of concern. Usually a state, any government agency or a government entity will see that there's a law here and they should engage in activities that comply with law, legal standards. So they're not going to be permitting bad permits anymore once they fix themselves.
Mr. Jacobs Curbstein, please.
Yeah, just a quick question on that note. As Mr. Trudis pointed out, the real concern is you get a permit, you're following the law, and you could still be in trouble under this. Does your proposal, basically they could stop, the courts could grant injunctive relief, and you ultimately are stopped in your tracks with valid permitting for building or doing whatever, whatever the permit's for. Does your proposal bar that entity from asserting affirmative defenses, such as detrimental reliance?
No, there's nothing that bars any defenses.
So if I get permitted and under this proposal, it's looked at and the courts deem the permitting inappropriate under the circumstances or under this proposal, I could, as that entity, assert affirmative defenses. I could actually countersue.
Yeah, absolutely. And you can and you don't even have to create a countersuit. You really just have to bring the evidence and show the court in equity, this is how it's going to affect us.
Okay.
It's unfair, whatever.
So I'm not barred from defending myself, and I'm also not barred from recovering any damages that I might have had by being stopped.
It would be a separate suit against probably the state, but yes.
Okay. All right. Thank you.
Mr. Trudis for a question.
Okay. I just want to make sure that, because I don't think this has been mentioned yet, people might get the impression that there is no enforcement of, for people, a citizen now, to protect the environment, but that's not true, right? Because under the Environmental Protection Act, any person, including a citizen, can sue, let's say, the Department of Environmental Protection for not following their own rules, right? And they can also sue if their rules are being violated. Both of those are true, right?
Well, to an extent, you can file a suit. A citizen has the ability to have standing under the 403, 412 Environmental Protection Act right now. But if you remember, there's a clear exception to the ability to enforce against bad permits. Okay, so that's one side. The second one is the inherent authority that courts have and citizens have for forcing governments, governmental entities and governmental officials to do their job and comply with the law. That is the mandamus power. So it's out there. It's been underutilized, in my opinion, but it's there. And so what this does, it kind of codifies that power, a pre-existing power, and it fulfills the gap that's currently found in statutory provisions.
What do you say? What is a bad permit?
A bad permit is, not only allows water pollution, but allows water pollution to the degree that it affects the interests of other people.
So a bad permit would be a permit that you believe was wrongfully issued, but it was lawfully issued by, let's say, the Department of Environmental Protection. Is that right?
Wrongfully in the sense that it infringes on other people's rights, yes.
Mr.
Okay.
Fisher for a question.
I'm one to believe that it's the old development that's causing part of the lagoon problem, not the new development. I think there's so many regulations in place today that you've got to meet that it's. So with that, there's been some questions in reference to, so I go through the permitting process, I'm a developer, I've done everything I'm supposed to do, and you decide that there might be some issues with my development, so you file suit.
Mm-hmm.
That's how it would work, right?
If you have evidence, yes.
Okay, so you put it in evidence. So now I go through a legal process that could take a year or 2 years, or takes a while to get hammered out. And
The court would, if there's a reason to look at it sooner, I mean, the court, again, in equity, would likely hear something, an emergency injunction hearing type of thing, or some kind of emergency, type of circumstances. But
historically, the courts don't move that fast, though.
historically in law, but again, this is a kind of a court in equity type of thing, which again is kind of outside the normal box that we normally associate courts with, right? It's a court in law, but they also have equity power, and they rule in fairness.
Okay, so let's say it takes 3 months, 6 months, whatever it takes. What's my recourse against you if everything was permitted correctly and the courts says he legally can build, and now I have a financial loss because of you putting me through that process?
Mm-hmm.
What would be my recourse on you?
So
And who do I sue, by the way?
The state.
So I got to sue the state the state issued the permit and said everything was correct in the first place. And some state agencies and some counties and cities, but they issued the permit and they said this was a legal permit. And we issued it, that he can develop it. You challenged that.
Mm-hmm.
And now I got to go back and sue the state because you challenged it?
There are lots of different legal tools available right now already. And I just want to preface this with the fact that current building and development codes are much better than they used to be. So the likelihood of these types of permits being at issue is much, much less than what we were talking about, in the 50s or 60s, whatever.
Yeah.
So moot. However, in hypothetical land, if a bad permit were to have been issued, and
I like to stay on the good permit that was issued.
if a good permit was issued
And you took me to court and you caused me to lose a sale, you caused me not to do development, I had a buyer that I lost, economy, interest rate went to 5.75, we go into recession, what is my recourse?
you can sue the plaintiff for bringing a frivolous lawsuit
And where's the assets of the plaintiff?
right now. Whatever, it's all case by case.
I know, but
So
what would it, like, if it's passed, what would the assets be for me to come after the plaintiff?
it would be outside the scope of Proposal 6, but should a frivolous plaintiff come forward with, you can't do that, this is, going to harm, without any proof, just, off the hip, whatever, there are emergency ways of hearing motions to dismiss or summary judgment or things like that. So it's real, there are ways to mitigate it, and there are overall processes in place to ensure that fairness reigns. If someone is intentionally, interfering with business or just, negligently, they can protect their assets, and there are plenty of laws and causes of action for that.
I think we can
sorry.
go on and on in this. Just a couple things. I think a lot of people have expressed the concern of, I think actually Mr. Fisher put the best way on this, is that when you do everything by the rules,
Mhm.
and there's the delay, and there's a financial impact, it's tough, too bad. And I think the other one that comes out is that you're adding a layer clearly to any project that's going to be going on. And time is money. And I think a lot of people are concerned about that. I know my time in the legislature, we had a thing called the Byrd-Harris Act, because the opposite was happening.
Mhm.
And now it seems like you want to kind of go the other way. So the Byrd-Harris Act is kind of important, is it not?
It is. I would say, though, that this falls into a previous question regarding, or a previous point that this is a temporary issue. All these fear-based type of scenarios are within a certain amount of time until the state stops issuing bad permits and starts issuing good permits, or ensures that those permits are good. So the threshold for proof is going to be much higher, and there's not going to be an issue once that happens.
Okay, I'll reserve my comments for when we're done with that. Thanks so much for your time. Great to see you.
Thank you.
All right, next we have Tony. Welcome. And then Mr. Myjack, you are going to be batting cleanup today. All right. Welcome.
Good afternoon. Tony Schiffalo, the historic Norwood House, Titusville, Florida. And this is your opportunity to make a historic choice, as has been pointed out, to make Brevard County the leader of the state of Florida in protecting our waterways and our wetlands, or to let it remain the state toilet. This referendum is not about tort reform or suing local governing bodies. It is about holding accountable those agencies which give permits without sufficient attention to effects on the environment. Those would be the bad permits. And the whole point of this whole process is to hold these permitting agencies accountable, to get them to change their rules that are bad, that allow pollution. Local governments want what's best for their constituents. State regulatory agencies are tasked with reviewing issues statewide and thus do not focus adequately on the environmental impact that many of their permits allow. Brevard County can lead by example by giving citizenry the opportunity to vote for the future history of the Indian River Lagoon instead of living with the past history of multiple manatee deaths and fish kills, etc. Speak Up Titusville has collected almost 4,000 petitions from Titusville registered voters. However, we've talked with thousands more Brevard County citizens who want to do something to save our beloved Indian River Lagoon. This initiative is something we can be proud to herald instead of being ashamed by the continuing manatee deaths and demise of other river species. We are the Space Coast, after all, the gateway not just to nature but to space. Brevard is the home of innovation and ingenuity. It's not rocket science to save the Indian River Lagoon. It is common sense, which I know is not so common. The initiative will give us leverage to hold inattentive state agencies accountable and require reparation in the Indian River Lagoon. We have gained many earthly uses for advances made in our space industry. We all know about Velcro, but there are earthly applications we can use to save our local environment. Carbon fiber heat sinks make lithium-ion batteries safer for electric cars and electric bikes. Satellite imagery helps farmers cut water usage in half. Zero-leak valves hold tight in demanding environments under hurricane conditions, etc. Numerous examples can be found in space and tweaked to reclaim our Indian River Lagoon. It all filters down to a matter of choice. Do you choose to make a stand for the right to clean water and put this initiative on the November ballot, or do nothing and allow the Indian River Lagoon to remain a dying, decaying cesspool in our front yard? Thank you very much.
Thanks for your time. All right, next we have Mr. Myjack to conclude on the public comments. Welcome back.
Thank you. Started off, ended up. Chairman, ladies and gentlemen of the commission, I'm Michael Myjack. 53 years ago, I was awestruck while wandering through the Marineland Aquarium. I was fascinated by the number of fish and the types and kinds that were available and seen right there in front of me in the Indian River Lagoon. If you've ever seen a sawfish up close and personal, well, to a preteen boy, it's pretty awesome. I just knew I was going to become a marine biologist. Maybe Mom would let me take one home then. 53 years ago, July, Neil Armstrong took that one giant step for mankind. The Indian River Lagoon had a vibrant fishing industry. Today, that industry has fallen off a cliff. We accept biosolids landing on our shores from other counties and water districts Further pollution from the St. Johns River Water Management District comes into our watershed, I should say. So shall we raise the SORAL tax to compensate for this additional pollution? How much harm can we endure? 53 years ago, on the 22nd, yesterday, the Cuyahoga River caught fire, sparked by a train driving over a trestle, igniting trash and oil on the water. It wasn't very big. It didn't last very long, 20 minutes, 30 minutes. It caused about $50,000 damage. The point was that it wasn't the first. It was the 14th since 1868. The city was Cleveland, which boomed after and during the Civil War for manufacturing. Why did it take 100 years? Why did it take until 1969 for them to complain about a river that, according to Time magazine, oozed into Lake Erie, lifeless and dead? Today, the Cuyahoga River is alive again. People fish it. They run kayaks through it. They recreate on it because the people of Cleveland and the people of Ohio took charge and decided that a dead river wasn't as valuable to the economy as having a vibrant community. When I worked for NASA Life Sciences, a buddy of mine, Don Page, had a little sign on his wall that said, "If you always do what you always done, you always get what you always got." What he's saying is if we do the same thing and expect different results, it's insane. We wouldn't have made it to space if we thought that way. I'm here to ask you to please consider the number of incidents of fish kills, the mammal mortality events, and the algal tides. If nothing changes, nothing changes. Please vote to move this forward to the citizens.
Thank you, Majak. Okay, we have reached the end of the public comments. We are now open to debate on this matter. As you know, we've had the 3 public hearings on this issue as well, so we'll have a vote on this today. Is there any debate on the issue before we move forward with the vote? Mr. Lubiker? No? Mr. White?
Yeah, if we're going to vote on this, I feel compelled to, because I'm going to vote a certain way, and I feel like I really need to say why, because I'm really torn, quite frankly. Because I've been a huge private property rights advocate my entire life. I've been a limited government advocate for as long as I can remember. But I'm also a guy that's 65 years old and a Florida native and grew up, swimming and skiing, water skiing and fishing and in the lakes of Central Florida. And I remember the Kissimmee River before the Army Corps of Engineers came in and straightened it, and now they're trying to put it back the way it was. And, my mother grew up down in Okeechobee, so, going down to the lake as a kid, all of those kinds of things. And this past Father's Day, I actually, and I'm beginning to think maybe we shouldn't have done it from what I've heard today, but my daughter, and I spent the day with my daughter and her family. We rented one of the pavilions at Rotary Park, and I was out there swimming in the Indian River Lagoon with my grandchildren. And so maybe that was a mistake. I don't know. I don't think it was, but it very well could have been. But I also know that we're a state of 22 million people, and we are soon to be a state of 30 million people. And who knows where we're going to go after that. And I know from the research that I've done, having run statewide before and having almost run statewide again this year, that water, quantity and quality, is absolutely going to be the defining issue for Florida going forward as we grow from 22 million to 30 million people and beyond. So I do believe that more has got to be done, and I absolutely, while I am torn about it, I'm going to vote for this because I think that it is really one of the only ways that we ever can, as a people, not just as a county, but as a people, at some point, we have got to take this bull by the horn, so to speak, and get something done about this, because we continue to spend tax dollars to buy up real estate in the state of Florida for government, while we continue to allow our waters to be degraded even worse than they've already been. And if we continue to allow that, then my grandchildren are going to be looking for another place to live. And I don't want them to have to do that. I want them to be able to grow up right here in Brevard County, Florida, and stay in Brevard County, Florida, if that's what they choose to do. And I'm frankly fed up and sick to death with the way that we as a state have allowed, not just here in Brevard County, it's not just the Indian River Lagoon. I'm not just speaking for what's going on right here locally. I'm speaking for what's been going on in this state for decades, for generations, and it's quite frankly disgusting. And when I heard the one speaker say earlier just in the midst of this debate, that Florida has no Class 1 waters left. None. And I just find that appalling. So something's got to be done, and so I'm willing to break with my political philosophy, my economic philosophy that I've been so supportive of for so long, and not permanently, and not and certainly not. Let me be clear, and certainly not across the board in all respects, because I'm going to continue to fight for private property rights and the rights of developers and the rights of people to use their property for its highest and best use and all of those kinds of things. But we have, by God, got to do something about water quality in the state of Florida. Thank you very much.
All right, others debate. All right, so with that, we will have a vote. All those who approve of this proposal to go to the voters, vote yes. All those who disapprove, vote no. Melissa, you please call the roll.
Robin Fisher.
Why do I always gotta be first?
Oh, no, serious. Consistency.
Let me say something right quick so people understand my position. I really believe that the problem in this county and other counties is it's the old development, not the new development. And because new development has all kind of restrictions and stuff that makes you comply with water quality. The old development doesn't. And being sitting on county commission for 8 years, I watch people fight me on repairing the current infrastructure that we have, and people be willing to tax ourselves to do that. And if you look at some of the problems we've recently seen, it's been old infrastructures that's really caused the lagoon issues and continue to cause it. Last 2 weeks ago, I had a manatee in my backyard dead, and so I understand the shape of the lagoon, and it was actually one property over, but I helped them drag it to the dock to get wildlife to come get them. So, I was supportive of the sales tax, was a big opponent of it, and actually fought for it. If y'all were coming to me and say, I would like to do a referendum to fix the current infrastructure, I'd be the first one to say yes to that, because I think that's what really the issue is. We need to fix the current infrastructures that's in place. And so until us as a group of citizens makes a decision to do that, I'm not supportive of somebody going through the process and could possibly not have their development happen after they've done everything legally, and then don't have the right to recourse if they lost an opportunity to develop their property. So because of that, I will not be supporting it, so my vote is no.
Okay. Please proceed.
Kendall Moore.
Yes.
Marcia Newell.
No.
Marie Rogerson.
No.
Blaze Tredis.
No.
Bob White. Yes. Matt Nye.
No.
Gabriel Jacobs Kirstein. Yes. Cole Oliver.
I'd like to echo Robin's comments. I sit on the St. Johns River Water Management District, so I'm very torn on this. Everyone, I think, in this county is extremely frustrated with the status of the lagoon, the waters as they are. And, we're all working hard to get there. And the write-up, it was a death of 1,000 cuts, I believe, is what the write-up said. And I think it's going to be a solution of 1,000 Band-Aids. This one is, I think, a square peg in a round hole. It replaces the certainty, whether you like it or not. We heard the comments, good permits, bad permits, with a vague process that puts permitting in the hands of the judicial system after everyone has gone through it. And there's the subjective nature of what is a good permit and what is a bad permit. You know, my neighbor may think if I go through the permit of putting a dock on my property, even though I comply with all statutes, that's a bad permit because now they have a dock in front of their house instead of, you know, the prior view that they had. So again, I'm going to have to vote no on this one, but I encourage the citizens to continue the fight. I'll be there to support the sales tax lagoon if it comes up again, and the continued funding at the state level. The state's investing heavily in the cleanup, and I encourage all the citizens to continue to let their legislatures know that we need to continue that investment. So with that, my vote is no.
Sue Schmidt?
Yeah, I want to comment too. I mean, I grew up in this county, and I was very supportive of the Indian River Lagoon tax. I spent my life when I was a kid fishing in the Indian River, going out with some people in boats, and when my grandparents would come down, they would go fishing from Pennsylvania because they didn't have it right where they lived up there. It is not what it was when I was a kid, I can tell you that, but neither is the St. John's. St. John's is not the same as it was when I was younger. In this case, I really truly believe, and I looked at what our attorney for the board laid out for us and what they believe is legal, and I really believe that this can be done in a better way, because otherwise you're going to see lawsuits and lawsuits and lawsuits, and I don't think that's the right way to go. I really think somewhere you need to go to your legislators and get an answer, and they're the ones that have done it. So I'm voting no.
Jordan Chandler?
Mr. Chair, you gave us the opportunity to have debate, but since everyone else is commenting, I feel compelled to make some statements as well. I made the comment previously that I had actually planned on proposing something very similar to this. And I made this comment just last meeting that quite often I think about what I want the future of our county to look like. And not to really be facetious, but I think there's really three of us up here who hope to have a long life of longevity, right? And quite often I really don't like individuals making tough decisions, on our behalf, because more than likely we're going to be the ones to live to see those decisions play out. And so I think when people say, there's a better alternative, there's a better solution, then propose one, right? And so I want to thank you all for bringing this forward, and I'll go ahead and support it. Yes.
Vic Lubker?
Obviously, very quickly. All the decisions I'm making up here, I base it on a decision matrix of three things. Is it necessary? Is it legal? Does it cause harm? This is definitely necessary. It passes that bar. However, the potential legal nature of this and the long, drawn-out, litigious kind of cycle you could get in with back and forth lawsuits, I think there's a better mechanism to get there, so I'm going to vote no.
Dave Newman?
No.
Mike Herodopoulos?
No. By your vote, the proposal fails. All right, we move to number, I think it was a vote of 10 to 4, correct?
Yes.
All right, next we move to number 7, by Mr. Tretis, repeal of Article 8 and Section 8.1.
Okay, this has been explained many times, so I'll try to be brief. This proposal would completely repeal, delete Section 8.1, election of school board members from the Brevard County Charter. This became part of the charter, I think in 1998, after it was put on the ballot the charter was amended by a charter proposal to go to single-member residence district by resident area, single-member districts. The problem with that is that Florida law provides that school board elections are countywide unless the school board votes to put on the ballot a proposal to make them single-member districts, and that has never happened. The other way that single-member districts can be created is by a petition of the citizens, and that did not happen. So this is inconsistent with Florida statutes. Commission Attorney Paul Gugelman, I don't think wrote a separate memorandum on this issue, but he did include it in one memorandum, which is, I'll just quote from it, number 5, quote, number 5, per Ms. Schmidt, Article 8 of the Florida Constitution provides for school board members to be elected from single-member districts. Is Article 8 legal? What can the county do and not do with regard to school board? Answer, more likely than not, were this issue submitted to a court of law, the court would find that the inclusion of the county charter of language providing for the election of school board members from single-member districts is not consistent with the Florida Constitution or general law, end quote. And its inconsistency is really highlighted by giving the example that this would lead to different results if it were a lawful way to go to single-member districts, because if it were lawful, this commission could repeal this and then put on the ballot, if it were so voted, to go to countywide elections. And then the school board, pursuant to state law, could put on the ballot to go to single-member districts. All could pass. You'd have a contradiction. The voters have voted for single-member districts and countywide. So that shows how it's inconsistent and it cannot coexist, this provision, with the Florida statute. So it was wrongly done in, I don't know, it was 1999, I guess it was done. It's been in the charter for a long time. But it really puts current elections at risk because a losing candidate could say, after I've lost, I'm going to file a lawsuit to have a new election countywide. That's what it has to be. This was an invalid election, so I think it needs to be removed from the charter as soon as possible. That's all. Thank you.
All right, any questions for the presenter? All right, we have one person coming to public, Sarah Mirsky. Welcome back.
Good afternoon. Thank you for having me. I just wanted to speak on the issue about voting for school board members countywide versus district-wide. Coming from a county that votes countywide, I think it empowers everybody, all the taxpayers and constituents in the county. And I have heard from the charter review that different districts have different representation of people as far as demographics go. But, you know, every decision made at the school board level affects every single student in Brevard Public Schools, not just the children of Cocoa and not just the children in Viera. It's all students countywide. And I feel it's empowering to the taxpayer that each voter would be empowered to have a say in countywide elections. And that said, it should not have been added to the charter review. I do agree with that in 1999. So thank you for having me.
Thank you very much. All right, next we have Marcus Hockman. Welcome back.
Thank you. Good afternoon, everyone. I won't hold up your time this much for this. My only question, and I brought this up last time, was the rationale number 5, the LGBT CRT in this. I feel that it has no bearing on this situation, and it shouldn't be in there. And I looked the other day, and it seems to be in there again. And I would like to know if that language can be stricken out before you guys vote on this. And I thought you guys had talked about that last time and saying getting rid of that language before deciding.
Well, I think one thing I would add to that is that whatever the ballot language is, that's something that we will work on as a group should this proposal in general be supported or not. The ballot language is just the most important thing I think you're getting at.
Thank you for being here. I actually have to leave for work, so I'm hoping I could run through a couple of these things.
Sure.
But, so I am in favor of this proposal, and I also would like to
educated populace here, but
we're voting on the proposal itself, but
and that's what elections are for. And we'll see if there's going to be a recall opportunity. I know we're going to take it up later, even though we're not going to vote on that today. But in this one, I think the process works, and especially when it's closest to the voters, and people can really go and let their school board member know where they stand on the issue. But with that, Mr. Tredis, you are recognized to close on your proposal.
What I forgot to say, it's very important that we're not voting on single-member districts or countywide. Minutes were a discussion of this proposal, and the school board put their county attorney, or excuse me, their school board attorney to research it, indicating that, of course, the school board, I would certainly think, would want to put on the ballot a proposal to go to single-member districts so that they don't have to run
for single-member or countywide elections. But I thought you also said in your open that the current Constitution says that unless a school board puts a referendum on the ballot for single-member districts, then the districts are countywide. Then everyone, so we are voting to change it from single-member districting to countywide.
No.
Dave Newman,
No.
Mike Herodopoulos.
No. By your vote, the proposal fails. All right, we are now on proposal number 8. This is the final vote we'll have today. We have some speaker cards. Mr. Burns, you are the sponsor of this idea. You're welcome to present.
Mr. Chairman, before Mr. Burns gets started, is number 8, is that a public hearing, number 3 as well?
We are number 8.
But I mean, is that you said that this would be the final vote today, is that?
Yeah, but this is the third.
Is to try to mitigate us being in the current situation where we have a vacancy for an indefinite amount of time on our county commission. Although this proposal will not affect our current position, it will hopefully help it from happening again. The state gave Brevard County and all counties the appointment process so that it's more clear and not so open to interpretation on how that appointment process should happen. I tried to make it as fair as possible, as well as mimic as much as I could the way that they appoint members to certain boards now, like the Soil Board. And I tried to put some timelines in there so that it just can't go on, indefinitely. So with that, I'm open to any questions. I'm also amenable to any changes anyone would see fit on how to implement that appointment process.
Questions?
I have a question.
Yes. Mr. Tredis, for a question.
So if there's more than 120 days left in the term, your proposal kicks in for elections, is that right?
Correct, because just logistically, I don't know if that would give the supervisor of elections enough time, less than 120 days, to actually put forth an election.
But there actually has to be 2 elections, right? Because county commission races are partisan, so there has to be a primary and a general. And that would certainly be impossible within 3 months to do 2 elections.
That's a good point. That's something I'm not sure about when those implementations would be. If the primary has to happen within 120 days, I think the general could happen, 30 days after that. So I think they can have both elections within the time frame. But I don't think it's reasonable to ask the supervisor of elections to do it in less than 120 days.
Well, maybe they should see. There's primary and general for partisan, and for nonpartisan, there can be a runoff if no one gets 50%. So to me, the language indicates that we're having a nonpartisan election for county commission. I see that as a problem.
I didn't see a legal definition in the statute for runoff. It's just, I think it's a lay term that's used by just voters. I'm not sure there's a legal definition for it in the Florida statute. I'm certainly, as I said, amenable to opening that 120 days up to maybe 6 months. I'm just seeing in the city of Palm Bay is the most recently time we've had a special election, and it was the city of Palm Bay, I think, even has a stricter guidelines than that. I think it's within 90 days they have to have their special election. But again, the city put that onus on the supervisor of election, and they cannot do that, much like we can't tell the governor to appoint someone. So the supervisor of elections came back to the city of Palm Bay and said, well, I can't have an election within that time frame because I have some general elections and judiciary things going on. So, but again, I'm more than happy to expand it to 6 months. I'm just trying, my goal is to make it so it's logistically possible, whatever that time frame may be.
Well, I would suggest you go to supervisor elections and see what the time frame is needed. But if you go to 6, like a term of office, it could be like weeks.
Well, that's exactly the arguments that were made during the Palm Bay City Council. So what you're talking about is you're going to remove the right of the people to vote over the cost of the election or the time that the term is going to be in there. Right now, for this current seat, we have 5 qualified candidates. So we have people who are definitely more than capable and willing to fill that position, but they can't because we've taken that authority away from ourselves and given it back to the governor. So the purpose of this proposal is to bring it back to the county so that we can figure out a way that we can have representation for these districts that currently do not and may not have in the future representation. Now, like I said, I'm more than willing to, mess with the numbers however we need to. But again, as far as the timeline is concerned with the supervisor of elections, that is flexible depending on what the supervisor of elections currently has on her plate. So if it's coming up on a general election or a judiciary election, and we're going to have a special election within that same time frame, well, she just doesn't have the manpower to facilitate both and to print more ballots. So that's when it starts to get into the cost. The city of Palm Bay thought it was given an estimate that it was going to cost $226,000, and it ended up costing, I think, $80,000 less than that. So even the estimates are kind of fluid, and that was coming directly from the supervisor of elections herself. So
let me clarify that. I think you bring up a good point. I literally just got this from the supervisor's office. A special election single district, the cost, according to the supervisor, would be approximately $382,000, and a countywide special election would be a little bit over $1.4 million. Again, I just want to get those numbers out to folks, however they choose to take those. Mr. Fisher, for a question. Sure.
I can't remember when Mr. Lober resigned. Was that
April Fool's Day?
You know,
Of course it was. Is that April 1st? It was April 1st as well.
In my mindset, I thought what should have happened is that the current county commission should have appointed somebody to serve in that position until this election, November, of 2022. So I don't know, what's that, 6 or 7 months?
Right.
To me, that's probably what I think should be happening in these scenarios, and not so much having to go to a special election. Just get it on the next available election and allow the county commission to appoint somebody.
Right, and that's what the second half of it does. So it allows for, when there's a short time frame such as this, that the county commission can appoint, but right now they can't because we've taken that authority from the commission and given it to the governor.
And in other counties, how do they do that?
I don't know.
Okay.
I can tell you this because it happened to me in the city of Titusville, 87, 88, whenever it was. I'm sorry, 97. I'm aging myself. But anyway, 97, Irene Davis resigned, and there was 1.5 years left on her term. And I got appointed by the Titusville City Council, and I served till that term was up.
Well, let me ask this question, then, since you're the sponsor, and of course, open to everyone else. Are people on our board open to the idea where I kind of like the idea where the governor does get to make the appointment, but until that appointment is made, that legislative body, if you want to call it that, but a city council or county commission can appoint someone until the governor appoints someone. Is that something that everyone's comfortable with or not comfortable with?
I say no.
Thank you, Mr. Chair. That's kind of my thought process as well on this, Mr. Burns. I'm in support of where you're going with this. I want my elected officials, my representatives elected, not appointed by all matters, if we can do that. I think the problem here is the timing that Mr. Lober left us in. To pull something like this off, I think it would take at least 270 days to be realistic. But my thought is, one, what you just said, Mr. Chair, and two, if the length of the term remaining is a year or longer, would that be something you'd be amenable to as far
Sure.
as putting that in the language? Because that may also solve the problem from a timing perspective on both sides. And then, as Mr. Fisher said, if the county commission wants to appoint someone, when it's under a year, that should probably be the way to go.
And you bring up a good point, and let me correct myself. So what happened with the city of Palm Bay, when Councilman Jeff Bailey resigned, he was literally within, I think, 1 day of it being 1 year. So city of Palm Bay's charter says that if it's less than a year, then the city can appoint. So he waited for 1 more day, which put it under a year. He got 1 more paycheck is what
Maybe
ended up
that should be
happening.
called April Fool's Day.
Yeah, that's April Fool's Day.
Well, let's
But
do
yeah.
this. I don't want to make this proposal on third reading. I don't want to like kick around this idea and throw something on the wall. We've got more meetings left. Think through this for the next, until our next meeting, and we'll kick around the idea. It could be an appointment in lieu of the governor. It could be an appointment and then the governor selects, whatever. Think through it on your own because we can't talk to each other. And next time we'll get together, we'll see what these options are. Clearly, I think we all agree that, as Mr. Tredis brings up, if it's too short a time period, it's too short a time period at a very high expense. And so everyone's clear with the numbers. It's $1.4 million for a countywide race and approximately almost $400,000 for a single district. So just to keep that in mind. Ms. Robertson?
So that I can ponder properly,
Sure.
I want to make sure I
Yeah.
understand. Currently, the charter allows, so we're talking about a year time frame, right? If there is less than a year, then it's an appointment currently, or yes, an appointment if it's less than a year. If it's more than a year, then there's a special election automatically, correct?
Correct.
Okay, so any amount of time that we take off your proposal makes it so we're changing a bunch of stuff for what, 6 months, right? If we say that you got to take 6 months to give them time to do a special election, then we're arguing over 6 months, correct?
Correct.
Okay, I just want to make sure I
Sure,
understand.
and we'll bring this up next time. But think through this, and it might be something we want to do or not do, but I just don't want to circle around and try to make a decision on third reading, as I would call it, and then wonder if it was the right decision. So we have plenty of time. We'll table this for today and move on to our next proposal.
And my final comment,
Sure.
the fundamental purpose is to bring back that process to the county instead of punting it to the state, even though I know that's what you.
No, I hear you, yeah.
Yes, but
I'm
that's the-
flexible. I think we just want to make sure that whatever decision made is one we really think about and think it through, because it's a legitimate issue as we're dealing with in Palm Bay and now more recently on the county commission. So thank you, Mr. Burns.
Thank you.
Mr. Chairman.
Ms. Schmidt.
Palm Bay had a run-up provision. However, the county commission does not, if it's 50% plus one, then they're elected, so they don't have that runoff, so keep that in mind.
Right, yeah, because they have a primary, if there's 3 candidates and 1 candidate gets 50% plus 1, then there's no general election,
Yeah.
so, but it's also nonpartisan as well.
If it's a primary and somebody has 30% and the other 2 are less than that, the 30% wins.
Mr. Chairman, one additional one, I think Mr. Burns said he'd be a little flexible on days. Maybe if staff is willing to check with the supervisor of elections about the timing on the apparatus, how fast they can do what they can do.
Sure.
I think that will help us as well to compare and get the timelines right if this board is willing.
And one other suggestion is, what do other counties do with their vacancies, just to, we can throw it against the wall too.
Thank you, Mr. Chairman.
Thanks, everyone. Okay, next we're going to move to number 10, by Ms. Roderson, dealing with supermajority passage of charter amendments. Ms. Roderson, you're recognized.
I believe the commission is smart enough to know what this is and doesn't need me to expound on it. If they have questions, I'm happy to answer.
Any questions? Mr. Tredis.
Would you be willing to eliminate that part about when it's effective? Because I think it's confusing and not necessary. It's effective when it's voted on. And if you look at it, if someone said, okay, if this isn't a charter, I'm trying to figure out the effective date, then go to your proposal, if they could find it, And that wouldn't help them either because it refers to or some other date indicated. So is that something you'd consider doing?
A follow-up question. Is it currently in the charter, because I could not find it,
Effective date?
when proposals become effective?
No.
Okay, so unless a proposal specifically states it, which none of ours currently do, there is no guideline. It's confusing as it is, right? So that's why when I actually didn't intend to include that part, but when I went to go borrow the language from the state law for this, it included that, and that's why I went and dug, and there was no information in our county charter. So to me, this actually provides clarity. You can still, if you want your something you're passing to be immediately enacted when it's passed, you can put that into your proposal. So it doesn't stick us to a particular timeline. It just provides if it is left out, this is what will happen when this proposal passes, basically.
Chair?
Yep,
Could I
Mr.
ask
Travis, sure.
Mr. Gugelman, what do you say on the effective date? Do you think it needs to be in there?
I think I haven't researched it, but I suspect that the effective date is when the amendment has been adopted and is filed with the Secretary of State's office, I suspect.
Can you verify that for us?
Yes.
Okay, perfect, thank you. I'm
Because-
happy to take it out if there is something somewhere that tells, I just couldn't find it.
All right, we'll take that up in the next meeting. Numbers, sorry?
Done with that one?
Yeah, I'm done with that one.
Can I say one thing before you?
Of course, go ahead.
Mr. Chairman. My concern on the effective date, if it's a charter amendment that could affect the county budget, that budget was probably approved in, I think, October. Is that typically right? So they went through budget hearing.
Approved in the end of September.
Yeah, so you approve it into September, elections November, you make that effective that day, then you could be putting the county in a bad situation from a budgetary standpoint. So I would probably say, I'd be supportive if you do it in the next budget cycle.
All right, let's look at that option, just so we understand, and maybe people can, because you all are very well versed in that budget world. And so when we bring that up next time, Mr. Anderson, if you
Yeah.
can find out from staff how that
Just-
might impact the budget, I think it's a fair
Absolutely.
question.
Just to clarify, this doesn't say that any proposal has to be effective at a certain time. It just says, so if you were doing something that affected a budget, absolutely, you could set that time frame for whenever. It just says, unless a date is given, this is the effective date.
All right, next we're going to move over to number 17. Mr. Tom Balutis is here for amending term limits for county commissioners. Welcome back.
Thank you, Mr. Chairman and Commissioners. No elected office, whether federal or local, is ever better off when run by career politicians. Those aren't my words. That is a quote from Governor DeSantis, who has advocated for term limits throughout his entire time in public service. But DeSantis isn't the only leader who supports term limits. A recent former president said, "We want to see new voices and new ideas emerge. That is why term limits are a really useful thing." That former president wasn't Donald Trump. It was actually Barack Obama. And no, hell hasn't frozen over. Term limits is the one thing that DeSantis, Obama, and Trump all agree on. Because it's not a left or a right issue, it's an American issue. It's the issue of allowing the people to govern ourselves. Florida has more term limits than any other state, and let's look at the track record. In the term limits era, we've been rated #1 in fiscal health. We've been rated the #1 state in freedom, and we're #1 in higher education. We have 1,000 people moving here every day, while states run by career politicians are sinking like the Titanic. Florida is seeing a renaissance of citizen-led government, and term limits are the reason for it. Now, we do have good term limits in our charter in 2.4, but the law has a loophole. It allows already termed out politicians to come back and run again. Why is that a problem? Because former commissioners often develop relationships with special interests while they're out of office. They can serve as lobbyists, and they can become quasi-incumbents with the potential to keep running and blocking new talent from entering the system. In many ways, that defeats the purpose of term limits, which is to create competitive elections and empower the next generation of leaders. Right now, in fact, we're seeing the benefit of open seat races, open seat competition in our 2 county commission races. In District 2, I think the voters have 5 options this year, and in District 4, the voters have 5 options as well. Because no incumbent is on the ballot there, citizens sense that they have a real chance to win. There are no barriers in their way, and so more of them have thrown their hat in the ring. Voters are going to get a lot of choices in those districts. That's good for democracy, and it's not something that you tend to see typically when there's an incumbent or a recent incumbent on the ballot. Because an incumbent or a recent incumbent has all the name recognition, PAC money, political connections needed to stack the deck. That's why incumbents tend to get reelected 95% of the time. So this proposal, Proposal 17, very simply, it would keep the existing term limits in place, but it would make it a lifetime limit rather than a consecutive limit. That's no different from how the 22nd Amendment in our Constitution works. Term limits on the president, 8 years and you're done. I'll say we've been dealt an amazing hand here in Florida with term limits. Now we need to double down. Please advance Proposal 17. And I'd be happy to take any questions that you have.
Thank you. All right, any questions?
I got one.
Mr. Tredice for a question.
I saw in the media, and I think 2 places, I think it was in the Brevard Business News and then Space Coast Daily, an article about your proposal, and the articles said there was polling done, but I forget what the results of that polling was. It seemed like it was pretty strong support. Can you tell us if that polling was done and what the results of it were?
Sure. Yeah, that polling was done back in April, and that was general polling on term limits for county commissioners, 8-year term limits for commissioners. It had been done in respect to the last proposal that would have moved it to 12, but we did learn some important things about term limits in that poll, mainly that in this county, term limits are as popular as orange juice, space program, and the beaches. I mean, 82% of people in Brevard County support the 8-year term limit for county commissioners, and the support is both broad and bipartisan. I mean, I've got some of the numbers here. 80% of Republicans support term limits here for commissioners, 85% of Democrats, and 82% of nonpartisan voters. And I'll say, Commissioner, you know, in this era, in this period that we have of political divisions where you know, we've never been more divided. The social tensions are very high. You know, we see people threatening judges. We see people rioting in Washington. It's unheard of to have an issue that is this bipartisan and that truly brings people together. So I would say when you have an issue like that, that is so unifying, like term limits, in a time like this, I mean, you really have to nurture and promote that type of issue in the interests of the Republic, and that's what we're trying to do here.
Thanks.
Other questions? All right, thank you so much.
Thank you, everyone.
All right, well, that will now be on the next meeting for the vote. All right, next we have amend section 5.2 on the recall. Vic, you're recognized.
Thank you, Mr. Chair. In the interest of time, since mine, like the rest of these, are not up for a vote till the next meeting, I'm going to hold my final thoughts till then, but I do want to ask one question of our council, if I may.
Of course.
If, based on my decision matrix, I think this is written where it's legally sound, it does no harm, and it's necessary. If the language was inserted to include school board members, would that change the legal part of the decision matrix? And if it's not something you can answer now, could you get that back to us by the next meeting?
Sure.
Okay. Thanks, sir.
All right, other questions? All right, any objection to moving forward to the next meeting? All right, seeing none, we're going to have that in the next meeting. Mr. Tredice, you're recognized in number 19, amend section 5.2.
This proposal would add 4 words to section 5.2 recall in the current charter. Those 4 words are "or school board member." 5.2 provides for the recall election of all county constitutional officers. That would be the sheriff, tax collector, supervisor elections, property appraiser, and the clerk of court. The only county constitutional officer who is not included in the recall list is school board members, and school board members are constitutional officers under Article 9 of the Florida Constitution. They're also considered county officials under a Florida Supreme Court decision that was cited in a memorandum previously by Mr. Gugelman. In support of this proposal, I really would cite Mr. Gugelman's letter to the Attorney General asking for an Attorney General opinion, which never was sent because that proposal was defeated. But it basically argues, I think convincingly, that school board members can be recalled. And there was in that memorandum, there was an opinion by the Secretary of State Division of Elections, where it was actually a question from Brevard County from an earlier Charter Review Commission about recall, and the Division of Elections answered yes, county constitutional officers are subject to recall. So I think the legal authority I submit is clear that the school board can be recalled under the same terms as every other county constitutional officer. Section 105, I think it is the provision that applies, 100.361, and it's for 7 reasons: malfeasance, misfeasance, neglect of duty, drunkenness, incompetence, permanent inability to perform the duties, and a conviction of a felony involving moral turpitude. So those are the grounds. So that's my proposal, and that's it.
Thank you. Mr. Hockman, or public comment, and then we'll get into our discussion, Mr. Madam Chair. Mr. Hockman, you're recognized.
Oh, real quick, I did put in for 18
No,
and
I know,
19.
my apologies.
No, that's
Yeah.
okay, because I did want to tie them both with the same question that you had for 19. I want to know, mine was a little bit different. I want to know if 18 is mute, then what happens to 19? Let's say you vote no, and what happens to 19, since it seems like to be tied together. So that's what I was confused on. And I'm going to talk about both if you don't mind.
Sure.
Okay. So what I also have a hard time with the 19th is that it was introduced basically today, right? Proposal 19 is today?
Amendment.
Amendment?
What happens, there is a proposal, and as we've had discussions, there's a amendment process, just like you would in any particle law. So Mr. Tredis has started with one thing and is amending it in this process. So he has the ability to do it. So it's not a brand-new issue, it's just making changes based on the discussions we've had as a group.
Okay. Because I was trying to figure out if that was being done because of Proposal 2 that was voted down last meeting. Does that make sense? So I was a little bit confused on that because you had already brought up of recalling school board members. And clearly, the group voted no.
Well, the joys of this process is that you can adjust. If one proposal goes down, it doesn't mean there's not another way to skin the cat. And this is another way of looking at it that way.
Yeah, that's what I see. That's okay. So I wanted clarification on that. Now, the problem I have with recall, and I understand this is more maybe a legislative issue, but all the things that you said, I agree with. They're in the statute that was written many years ago. Is there seems to be, to me, what I have a hard time with, no due process. And that's the biggest thing I have with that. There's no due process to say, how do you clarify that there's drunkenness? Who decides that? Who judges that? There's nothing in there to me that says that. Who decides to do that? Usually you go to courts, because all this is based off of the Florida Constitution and the United States Constitution, correctly. So my biggest thing with the whole recall is, like I said, no due process. And think of it another way. Let's say next year, and this is about the school board members, let's say, naming some names, let's say there's Wright becomes District 1, another one becomes District 2, and you have 4 Republicans and stuff. Let's say you have that, 1 Democrat on there right now, even though it's nonpartisan, but we know it is partisan, okay? Let's say you have that. Then it comes up that something comes up like the bathrooms. Having transgenders in the bathrooms and everything. And let's say they vote no for the policy on that. Let's say they change the policy, they say you can't have that. But then you're voting to get that, means you're going against the federal statutes or federal laws concerning that. So does that mean, or we open up Pandora's box where then you have a whole bunch of people say, well, you know what? Those 4 members voted to change the policy, but they voted against federal law. Can we recall them? Are we sure we want to go into that aspect, especially when there's no due process in place to say, did they break the law? Did they break the policy? Okay, that's what I'm looking at when I see that. That's it.
Okay.
On those two. Thank you.
Ms. Schmidt, sure.
The way I understand it, and correct me if I'm wrong, Blaise, is that it would be going by Florida statutes, and which means malfeasance, misfeasance, and general law, which does not include policy. What went down was when it included policy, because you could make a policy saying all schools are going to be pink. And if somebody doesn't like it, you can recall somebody. Well, that's not what general law in Florida is for county commissions and city councils. And so, and correct me if I'm wrong, Blaze, this has changed that then to include Florida general law.
Yeah, that's exactly right. What was defeated was a completely different proposal with 6 single-spaced pages of a proposal, and this, all it does is it includes school board members, and they are under the same Florida statute recall provision that all the other county constitutional officers have been under since the beginning of the charter.
But also in there is neglect of duty. So all you have to do is, isn't there like neglect of duty is part of one of those 7?
Right.
So all you have to do is you bring it up for a recall, say, hey, you know what? They neglected following federal law. Can we have a recall of a school board member that voted to change the transgender policy? That's what I'm asking.
It's not, it's Florida law, not federal law. Okay.
But they can look at federal law, though. Why can't they look at that and do that? That's my point. It's so in general. That's the confusion I'm coming from. Not trying to argue, but that's how I see it as.
Mr. Chair, can I weigh in?
Of course.
Mr. Hockman, here's the thing. First of all, for clarity, I don't know what his proposal was because of Sunshine. We don't know what each other write until we see it in the agenda package. So there is some overlap, and you're right. I think when our legal counsel comes back with his opinion on that, I am confident he's going to look at both of these together related to Florida statute, and then you're probably going to see what's going to be the final package come out in the next meeting.
Okay, thank you.
Mr. Chair, can I comment too?
Sure, of course.
So I've done a little bit of research on the case law under section 100.361, and there's not much, but there's some. And usually what seems to happen is if there's someone who's subject to a recall, they will go to court and try to get it dismissed. And they will argue that there's not any evidence of the 7 grounds listed in the statute. One case I remember, and they're usually really small towns because it's really difficult. And when we talk about due process, I'm going off track here. There's so much due process in this statute, it's hard to imagine that a recall would have a very good chance of passing. 5% of the electors have to sign a petition. The grounds are listed. If you get 5% that are certified as 5%, then it's got to go back and get 15% of the electors. So there is due process galore, I think. But the courts, like in this one case of this little town, the petition said that neglect of duty because the city councilwoman didn't work well with the clerk of the court or clerk of the city. And it was dismissed, saying that's just ridiculous, you know, this opinion that you don't get along, and it was dismissed. So there's also that due process in it to take out completely baseless, irrelevant, silly, you know, allegations like I think like you're referring to.
Okay.
Yeah, thank you. All right, we have a few other appearance cards for number 19. Janice Crisp, followed by Diana.
Hi, thank you again for allowing me to speak. I'm going to try to say this calmly. Why should the citizens have the right to recall the school board members? School board members are the foundations of our community. They're meant to be the guardians at the gate. They're here to safeguard the education we work hard to give our children. Mind you, I said education and not indoctrination. The education standards are set by the state and given to school boards and teachers. Parents are in charge of the shaping of the child's character, morals, values, ethics, faith, etc. Looking at the Florida State Board of Education legal strategic plan through 2025, you will only see items that pertain to educational subjects: science, math, reading, social studies, graduation achievements, and skill level for both students and teachers. The school board members are expected to conduct themselves without malfeasance and misfeasance and conduct themselves in a professional standard. You will see there is nothing in there about gender identity, better known in the DSM-5 as body dysmorphic disorder, which we have seen in the past 2 years paraded in front of students, the media, and school board, with our children and in front of the community. This has become the new cool kids thing to be and the new woke thing to claim you are a champion for if you are a school board administrator. There is no mention of CRT, no mention of spewing hate for your country, your government, or rewriting history in those educational strategic plans. However, the school board has become a dictatorship of its own. They have used the Brevard County Sheriffs to shut down free speech. They have threatened members if they speak something they don't like. However, they have not used the Brevard County Sheriffs to take pornography out of schools. To this day, we have pornography in our libraries that are available to children 12 years and up that are in all of our schools, that there are federal and state laws, that I have a book, if you'd like to see, of all those laws that prohibit all of that. They have threatened to kick out actually they did kick out the public and had meetings that went against sunshine laws. They changed the rules of public speaking from 3 minutes to 1 minute because they don't like what you have to say. They can't come up with a discipline plan. May I have a few more seconds? They can't come up with a discipline plan that does not kick out underserved African American and Latino children from their public schools, and it ends up putting them in charter schools and private schools, yet the media has been full of one member's rant about unproven claims of harassment, no mention of the children's harms by lack of duties and by the school board. The school board in Brevard County has become a place for certain members to execute an agenda and not their role as caretakers of the children's education. They have lost any sight of their mission and vision. There are lawsuits totaling over $100 million and more on the way. They did not report a coach and school volunteer who was arrested for sending nude photos to a student, and when the state did finally find out and ban him from being on school grounds and volunteering, he is still allowed to be on school board grounds. Home rule says we can create our own charter, rules, and our own government under state law parameters. We must include these board members to protect our future children. We learn from our mistakes, and we must make today, we learn from our mistakes, and we make today so we do not continue to make them in the future. I'm here to hopefully help protect our children, because there's a lot going on in the school board that people need to realize if we don't stop it now, it's never going to be stopped. Thank you.
Thank you, Ms. Chris.
Just a
I'm sorry, a question?
Yes.
quick question.
Yeah,
Just
sure.
a quick question. You seem pretty impassioned, and understandably so. What is your role with the school board?
I actually started because I had a daughter who she started teaching at a charter school, at one of these charter schools, and the whole school was children, African American children, who were kicked out of the public schools for so-called behavior problems. My daughter was 23 years old and had no problems with these children.
Okay.
And I've been active in politics for a long time, and I was asked by parents to take up the school board issue over a year ago, and I have a group of over 400 parents in a certain district that has said, please help us, and I have a group of them working with them, and it wasn't with the recall that everyone knows about. This is a whole separate group of people who want this recall to happen, want to be able to, if somebody messes up, if we order something from Walmart and it's broken, we can take it back. If we elect somebody who lies to us, we should be able to send them back. I mean, that's just common sense, and we've been lied to for 2 years.
Okay. Yes, ma'am. I appreciate you answering that.
Thank you.
All right, next, Diana.
Good day. Thank you for the opportunity to speak to you again. Previously, I was up here and kind of gave you a little definition about the word malfeasance, and then I gave some examples of what I found to be instances that were occurring with our current school board. The things that Ms. Crisp talked about, a lot of them involve me. I was almost escorted by a deputy from the dais, or from speaking, because Ms. Belfort didn't like me using the word penis. Although I have seen more horrendous pornography in the books that were reviewed by Moms for Liberty that sit on the shelves of our schools, I didn't think that word would be offensive to anybody. And it was in regards to a gentleman, a teacher, who was removed from school. And even though his conviction and his arrest were not followed through, he still created and did the act of showing his male appendage to a minor student. That's a fact. That's not going to change. And the school allowed him back on school campuses recently. And to me, that's appalling. There are so many other instances that Janice spoke about. Back in October, the school board was made aware of the pornography in the schools by the book that Janice found called Gender Queer, that I brought to the school board and actually read passages that they became so mortified that they shut me down at that meeting also, saying that I couldn't use such language, but yet this book sits in a junior, senior high school. That was October. We are now into almost July, and these books still sit on the shelves. There isn't a single police force or the sheriff who will do anything criminally against these school board members. When they were made aware of this, they could have very easily removed the books and then reviewed them and decided with the parents what was appropriate to be into the school system. But none of these books are appropriate. If you go on to Moms for Liberty's public page, you can read every single one of them. And if it doesn't make you embarrassed and sickening, there's a problem. No child should be reading this. No 16-year-old, no 12-year-old, no 18-year-old. It is just abhorrent sexual verbiage that's being fed to our children. We should have, as taxpayers and voters, the ability to remove anyone in a position that makes those decisions that affect our children's lives, their well-being, all of it. And I think that this current school board, some of the officials have shown all of the criteria to be removed. And the public has been saying for months, this is what they want. They may not come here and verbally talk to you, but everybody's on social media. You all see it, you all hear it. The public wants a voice, and this is the most important place to have a voice because they're not listening to us at the school board. They shut us down. A minute is ridiculous and insane to try to make a point. And the fact that if they don't like what you say, they cut you off camera, besides having the deputies threaten to arrest you. Thank you for your time.
Thank you. All right, there are no more appearance cards in proposal number 19. Are there questions for the sponsor?
I wanted to ask a question, if I could, of Ms. Trinas.
Yeah, sure.
On your page 1 of what your attachment is, and you have section 5.2 recall, and what I'd like to ask is that last line where you have in charter counties, if you would just put a period after recall, and then put as stated in 100.361, paren 2, paren D, Florida statutes.
I'll take it under advisement.
Okay, that's fine. It goes by what is already in the charter right now for county commissioners and city council, and I was just following the same and with the Florida statute that it applies.
Okay.
Okay.
All right. So that'll be, without any objection, we'll take that up in the next meeting, and Mr. Tredice will take that suggestion under advisement. And I think we had that issue meeting back, so maybe it might be a good idea to accept to get the necessary votes. All right, so we're on number 20 by Mr. Jacobs Kirstein. Gabriel, you recognized.
Yes, thank you, Mr. Chair. I know this is a highly contentious issue, and I'm assuming that everybody out here is here to speak on this? No? Okay. So I'm going to do what Mr. Lubker did and save the majority of the final comment for the third meeting. But it's just a couple things I wanted to point out, that I did go back and listen to the last meeting on this issue, and there were several things that were brought up, one of which was a discrepancy between the subsection 3 that I proposed, as an amendment based on this board or this commission's feelings on the issue. With that being said, 7.3.23, I believe, talks about the 3-attorney panel as well. However, it's in the context of petition. So amending the charter by petition, not through the CRC, the Charter Review Commission. So as a result of that, I don't think that's really an issue. The other one was brought up by Mr. Moore in that he'd like to see the ability to hire the 3-attorney panel or retain the 3-attorney panel be put in there as well, and so that we're doing that as opposed to the county commissioners. I do agree with that, and that will be added in. The other aspect was the review of the ballot language, so instead of just reviewing the proposed amendment and then getting back to us, they would also review the ballot language to make sure that that is constitutional, single subject, etc. Personally, I don't care either way. I think it's an added protection to have it in there. However, if this 3-attorney panel is reviewing something and they see that the proposed language is legal and they agree to give it back to us to pass or pass it on to the ballot, the chances of us screwing up the ballot language to that extent is pretty minimal. So I don't think that added protection is all that necessary. So I'm fine with taking it out or leaving it in. I really just want the consensus from this group, from the commission. So if anybody has any thoughts on that, I'm all ears. Lastly, the proposed amendment that you have in front of you is actually the first draft. There's been a second draft that was submitted, I believe, on May 2nd. So I just want to see that for the next meeting that updated draft is included or is the one that we have in our packet. But I will also, like I said, make those changes and submit that. So maybe just the new submitted proposal will be the one that we have in our packet. So if there's no confusion, it's the third meeting, we'll vote on it accordingly. Other than that, that's it.
All right, questions?
I have a question.
Mr. Perez, for a question.
Okay, we passed today a proposal on 7.4.1.
Right.
Do you believe that what was passed today is consistent and won't be conflicting with, and can basically, yours could be added to what was passed today?
Right, so kind of like with 17 and 18 and 19, what was brought up with those, they're on the same subject. I do see a lot of similarity. I think that this one just goes a few steps further and is a little more detailed. However, they are in the same vein, so I would have no problem kind of either combining those or keeping them separate. It doesn't matter to me personally. But I don't think that they would necessarily conflict. I think that one would more or less take over the other, so to speak. Does that make sense?
Yes.
Okay.
All right, further questions? Mr. Moore.
One quick one, Mr. Tredis, on the one you were referring to. I think Gabriel's done great work. The question is, remember yours says, hey, look, if the panel says no, that it comes back to, I think yours said, to the commission or to this body. And I think, one of the things that you expressed some early concern about was the county commission's potential control over that process. And so yours said both. I am a huge fan of it coming back to this body, and so it's a scheduling factor. As long as you've provided enough time, it comes back to this body for it to be amended, changed, or the other. So that's the only potential conflict I see, but I think, yours was well received earlier, but this one brings it back ultimately to this body as opposed to this body or the commission. So we just want to think through that, how that logistically might work.
Well, can I answer that, Chair? So the reason it said or back to the county commission was because that 3-attorney panel also applies to charter proposals from directly the county commission because they voted 4 or 5 for it. That's why it's included in there. I want to make it clear that that wasn't a mistake. It's because there's 2 ways that the 3-attorney panel is invoked, and that's why it was included. I'll just also, while I'm speaking, just suggest to Mr. Jacobs-Kirstein that, I don't know, I really think mine is one sentence, and it brings it back to the commission if they want to do anything with it. Yours is very specific about doing this, doing that, doing this, doing that. I don't know that that's necessary, quite frankly, because it's like, give it back. They want to submit something else that didn't pass the three-attorney panel, then they'll do it. But this is like very detailed about what's supposed to happen within the commission. You shall do this, you shall do that. I just don't really think it's necessary.
Okay. I don't really have anything on that. I'm just trying to do, I have no personal stake in it for obvious reasons. You know, I'm just trying to do what I think that the board had or this commission had kind of, the direction we wanted to head in as a group and based on the advice of our council, you know, achieve and what we're all looking to do and not leave any discrepancies. That's all.
All right, further questions? All right, seeing no further questions, we'll push that to the next agenda. Next, we have proposal number 21 by Mr. Nye, amend Article 8 by adding section 8.2.
So, according to a memo from Mr. Googleman, this is outside the purview of this body. So I would like to withdraw that, but what I would like to do is I'm going to write up a resolution that I would like to bring to the next meeting, encouraging the school board to, you know, take this up as an issue on their agenda. So consider that one withdrawn.
All right, without objection, that is withdrawn. All right, we'll move to number 22, also by Mr. Nye, revised citizen advisory process.
I think this one's self-explanatory. So basically, you know, there's already, we put in place, I guess it was back in 2010, the proposal to have a citizen review or advisory process to essentially make the commissioners take up an issue and take a vote on something. And one of the citizens that came before us previously expressed some concerns about the frequency, and I tend to agree that it's very easy, you know, the way things are, to miss the deadline for having it only once a year. So proposal is to increase that to twice a year. Everything else stay the same.
All right, questions?
No question, just a comment. Matt, I like the change you made, and I'm all for it.
Thank you.
Do what?
Say it again.
I like the change you made.
Say it one more time. I'm really liking all this positive feedback. Yeah.
Okay, he likes it. Okay. Mikey likes it. Good. All right. All right, are there further questions on that idea? But this would literally be a charter review vote to have it twice a year.
We have to vote. Right? Yeah.
Okay. All right. Any objection to that? All right, we'll bring it up in the next meeting. Number 23, Mr. Nye.
All right, basically same issue as before. This appears to be not consistent with state statute. We're talking about, I was proposing adding 2 school board members to be elected at large. Again, this is, I added these because of the contentious nature of the discussions we've been having and just trying to give people options to at least talk about different ways to address some of the issues we're seeing related to the school board. So this, again, is, according to the memo, inconsistent with state statute, like it's just not something that we should do here. So I'm going to do the same thing. I'll write up a resolution, bring that before the body, but consider this one withdrawn as well.
Okay, without objection, show 23 withdrawn. We're now on our final issue of the day. That's Jordan Chandler with number 24, add section establishing workforce housing trust fund.
All right, bringing up the rear here. So as stated, the purpose of the trust fund is to provide a continuing non-lapsing fund for the Brevard County Commission to create and sustain affordable housing throughout Brevard County for renters, homeowners, and to increase workforce housing opportunities. Just real quickly here to provide you with a few points of data. According to the Florida Realtors year-end report, at the end of 2021, the statewide median sales price for a single-family home was $348, which is 20% higher than the previous year. At the same time, rent has increased more than 20%. The Schimberg Center for Housing Studies showed a gap between the number of rental households and the number of available and affordable rental units here in Brevard County. Schimberg's 2016 study showed the gap between supply and demand for renters earning less than 40%. The area median income was 4,261 units, but their 2019 study showed that the gap had actually risen to 11,380 units. That just provides you with a little bit of data, which puts into perspective sort of the crisis that we're facing. In the proposal, I laid out a litany of revenue sources that the county commission can consider. There's 4 in particular, but number 5 is any other revenue sources as established by ordinance. As mentioned before, the current Affordable Housing Trust Fund was established by ordinance in 2007. The only funds that are actually being allocated to that fund is what they call PILT funds, payment in lieu of taxes. Want to discuss the potential funding that is available outside of that particular scope. There's some additional dollars that will be coming down the pipe outside of what the county commissioners will be able to allocate. Number 1, ARPA. I believe that there is still roughly $30 to $40 million, if I'm not mistaken, that the county has on hand, and a portion of those dollars can be set aside for this trust fund. To my knowledge, the city of Melbourne has actually set aside $2.5 million of theirs to tackle homelessness, but as well as to provide supportive services for housing. And then also the city of Palm Bay most recently allocated $5 million to tackle the same issue. Number 2, the nationwide opioid litigation. Currently, just the county alone is on tap to receive roughly $5 million. That's for unincorporated Brevard in the opioid litigation settlement against Big Pharma. And because of the supportive housing aspect of this proposal, that is a very viable source of funding for this trust fund. Number 3, the President's May 16th letter. President Biden has issued a plan to allocate $150 billion for the creation of 500,000 affordable housing units by 2025. Specifically, $25 billion of those dollars will be grant dollars provided to local government entities, agencies that have a trust fund similar in place to this to be able to tackle the housing crisis in their communities. Number 4, the governor's stance. Just yesterday, Governor DeSantis announced over $28 million in funding for 23 communities across Florida to promote workforce housing, training, and sustainability, as well as broadband infrastructure and planning. Some areas such as Alachua County received over $4 million for their effort to spur up economic growth. And so just wanted to list some of those for you because this is literally a once-in-a-generation opportunity that we have here for us to really garner $50 million plus over the next few years for this trust fund, okay? Now, there were some questions that were raised at the previous meeting that I want to just touch on here very briefly. As previously mentioned, the current trust fund that was established via ordinance in 2007 has not done enough to move the ball forward. The current Housing Assisting Trust Fund has a little over $401,000 in it. To be clear, this has never been swept by the county commission and is used to support our homeowner repair, rehabilitation, and reconstruction program since there is actually not enough for larger projects. Number 2, to your point, Mr. Chair, we do receive SHIP funds. I know you had some questions about Sadowski. For the decade prior to the current fiscal year, much of the funds in the Sadowski Trust Fund were swept. Obviously, there were some years that were better than others, but the low point, fiscal year 2012 through 2013, we only received $119,496. The SHIP fiscal year runs from July 1st to June 30th. And just to give you a more recent up-to-date particular standpoint of what dollars that we've actually received, in 2019, the county received $468,000 in SHIP funding. In 2020, the county received $587,000 in SHIP funding. In 2021, the county received $2.2 million in SHIP funding. In fiscal year 2022 through 2023, the county is set to receive $3.3 million. And I would say that one of the issues with SHIP, due to the amount of rules that it has, it doesn't really lend itself a large-scale creation of affordable housing or workforce housing. For example, there are expenditure deadlines, 2 years to obligate those funds, and actually an additional year to actually expend those funds. So funds technically can't be reserved. Additionally, it is geared more towards homeowners. 65% of the funds must be spent towards homeownership, including repair, rehabilitation, reconstruction, and first-time home buyer programs. Number 3, residential density equivalent units. I know that this was a sticking point of Mr. Tredis, and went back and did some due diligence, because I think that your point, and I don't want to put words in your mouth, but I think you had some concerns relative to this particular language being able to allow something outside of what is currently approved for zoning, right? So under the current code, Section 62-6301 and 62-6304, when talking about affordable and work housing incentives, it delineates what is actually currently allowable in terms of required set-asides, and when trying to receive density bonuses and incentives. The incentive strategies and recommendations regarding density flexibility that were provided to the Board of County Commissioners to keep within the county's comp plan were approved on December 21st, 2021. And the recommendation was to continue to allow greater flexibility in increasing density levels to encourage the creation of affordable housing within the county through use of ordinances and codes. And so therefore, I'm not proposing anything that is not allowable under the current county code and comprehensive plan. Matter of fact, it really mirrors what is actually currently allowable. And so just wanted to try my best to touch on some of those questions that were raised at the previous meeting. Thank you, Mr. Chair.
Thank you. Questions? Ms. Schmidt?
I just have one, Jordan. Did you also look at what was approved at the last county commission meeting in May for funds for housing and some new monies that the board approved?
I'm not sure.
Okay.
Were there any funds?
In the event you haven't, maybe you
Okay.
could just check on it
Okay.
anyway.
Other questions? Ms. Tredis?
Mr. Chairman, I'm trying to figure out how really your proposal differs from what already exists in the county, the Housing Trust Fund and Unit Mitigation Bank, because I looked at that, and your proposal is really verbatim that county ordinance from halfway down through the second page to the very end. That is word for word. And your purposes language doesn't dedicate any money to this fund, makes it discretionary with the county commission. So I'm really having a difficulty understanding what this adds to what the county already has. And the money you're talking about, if that money came to Brevard County, why wouldn't they just put it in what already exists? And also, now I'm getting more technical, but when you talk about these residential density units and density bonuses, none of that is mentioned or defined in your proposal. And these proposals, in my opinion, need to stand on their own. I mean, you can't go to some other county ordinance and say, well, that's what he meant, or that's what's meant here, that's what's meant. I mean, this is what is in existence is really complete. So I'm just having a really difficult time understanding what does this add to what already exists. Doesn't commit any money. And also, I mean, just there's another technical thing. At the very end, it says that the county commission shall adopt one or more ordinances implementing the provisions of this section and or strictly enforce existing ordinances, which ordinances may be amended, blah, blah, blah. So, I mean, the language of that, the county, if this were to pass, could say, okay, we're not going to do any ordinances towards this. We're just going to strictly enforce what we have. So those are my comments. Maybe you could address them.
Yes, sir, Mr. Chair, and thank you, Mr. Tredis, for those comments. Really, the impetus behind this proposal is, as I really mentioned before, this current Affordable Housing Trust Fund has been in existence since 2007, and so although this particular proposal that has been crafted does does to a similar degree mirror what is already in county ordinance and code, I wouldn't hold my breath that the county commission would do something outside of, more especially the funding sources that are outlined in this proposal. Gives a greater scope and detail for them to look at more options other than just PILT, as I stated before, which is currently in code. And so, this is really a framework for something much bigger.
Well, the county isn't just limited to the PILF funds, though, right? I mean, PILF may be a dedicated funding source in the existing code, but certainly they could use any other source of money. Isn't that right? Do you think? Do you agree?
Correct.
Well, I don't know. I still have my position, which I'm not understanding what it adds to what already exists.
Thank you, Mr. Chair. Jordan, these aren't questions. These are actually, I'm just going to share some thoughts because of sunshine. We can do this right now, and then next meeting, maybe get a little deeper into the dialogue. This one, kind of like with my friend Mr. White, kind of cuts against my political grain. I'm very empathetic to what you're trying to do here. Grew up in a similar environment as you, single-family environments outside of Chicago. I'm going to date myself. They have these buildings back in the day they used to build, these brown kind of apartment complexes. Government subsidized housing. I lived in those in the 60s and 70s. That's probably when your grandparents were born. But I'm also a fiscal conservative kind of guy, and I want to just throw this at you, and I'll tell you exactly where I'm at in my notes so you can look at it. Section C4, the language mandatory or voluntary payments, residential. Are you talking about mandatory impact fee payments? You don't have to answer now. I'm just throwing that at you, okay, for the sake of time. Section D, 2 and 3, do not revert to the general revenues of the county and any appropriations do not lapse. So is this going to go on in perpetuity? And if it came out of the general fund and could not be fully spent, should it not be able to go back to the general fund? Again, just throwing it out there so you know where I'm at. And then last, section E, 3, 4, and 5. Am I reading this to be kind of the PPP concept, public-private partnership, or NPPP, nonprofit public-private partnership type initiative? And if so, why would we want to not put more into a larger community versus 65% of single-family housing to where we could have on-site daycare and you could have a computer lab, those kind of things? So just throwing those things out there for you because I'm going to ask those questions next time around. Thank you, Mr. Chair.
Thank you. Further questions? I'll just ask you one question. Does your proposal obligate the county commission to spend one nickel?
And I received those questions before, and it's obviously what Mr. Tredis is alluding to as well. I'm going to be bluntly honest with you, since we're here in the sunshine. I think really putting a dollar amount in this particular proposal, now maybe I'm a little bit more optimistic, right? Maybe I have a little bit more trust that the county commission, with the funding sources that are outlined, would do the right thing. But I believe simply that based on where we live, and knowing that we have a cap in place, so a vast majority of the trust funds that I actually looked at in various other counties and even across the United States use general revenue as one of the most viable sources, right? We don't really have that luxury here because of the cap that we have in place. And so, therefore, I think actually telling the county commission that you must spend these dollars in such a way, of telling them in essence how to budget from a charter review perspective, charter amendment proposal perspective, I just didn't really feel that that was appropriate in actually delineating or putting a dollar amount in here. Maybe, based on what I'm hearing, that we can throw out some numbers relative to a minimum requirement, right? Whether that be 0.1% of the county's annual budget, right? So I think this year that's 1.6 $1.65 billion, and so that would be equivalent to $1.65 million, right? But I think putting in that regard, I really struggle to believe that that would get any support on this particular dais. So.
Was that a yes or a no?
I might use that second in your proposal there, where we can come and speak before the county commission, the citizens advisory process, come the second time to make some arguments known. But at this particular time, based on the way that it's currently written, it says that they must allocate funding each year, but it doesn't say that they must allocate a specific amount.
Well, I would just say this. I lived under it in my time in the legislature. Unfunded mandates, so to speak, from constitutional amendments cause a lot of issues. And I think we all understand the struggle right now with affordable housing, one, because of housing prices, and I think in the near future because of interest rates. I mean, I think you're going to see this housing bubble take a little hit. I'm very hesitant to move forward on it because I don't feel like we should. We started our discussion today, at least on our proposals, with Mr. Tredis's charter cap, and we talked about all the budget pressures that are there already. And I think it'd be unfair if I then told the county commission, now you got to spend X amount on affordable housing. And it just gives me a lot of pause. I would just recommend, just like I had asked in the last meeting, that you really tighten this up, because it's kind of like the water proposal. We're very sympathetic towards it, but as I think Mr. Nye brought up, the accurate phrase is the theory of unintended consequences. And once you start squeezing that water balloon one way, things can get a little tricky. And I think we're walking into a very difficult time in our economy right now as we're all facing a recession. And again, I think there's a lot of support in the concept, but you're really going to need to tighten this up so that we could potentially move forward with it and have a little bit more clarity, because as Mr. Nye just asked you, pretty direct question, I don't know, I think you need more clarity, just to be the kindest term I can give you, before you're going to get 10 votes. And so our focus is on one area as opposed to this broad concept. I like the concept. I'm concerned about the specifics, and I hate to put an additional burden on the county commissioners. They're going to be in a difficult spot, I think, in a year or two on our budget. So I don't mean to talk too much. That's just my concern. Other questions? All right. So we are going to take that up in the next meeting. So proposal 24 moves forward. All right. Going back to our agenda.
Mr. Chair.
Sure.
And just since we're in the sunshine, I wanted to throw this out there as well.
Sure.
And I think this meeting will actually take place before our next, before our July 7th meeting. But there were some companies or corporations that actually reached out to Commissioner Zonka and myself relative to what the county is doing in terms of workforce housing. And so based on how that meeting goes, we'll bring that information back as well, or what that discussion was like at the next meeting. Okay.
And I apologize. There's a couple people that had an appearance card on that, and I missed that. Mr. Klimowski, is he still here?
I was just checking on that, actually.
You're recognized for 3 minutes. Welcome back.
Thank you. And thank you, Chair Herodopoulos and the fellow commissioners, for being here. We, the people of the United States, in order to form a more perfect union, establish justice, promote, ensure domestic tranquility, provide for the common defense, and promote general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. That's the preamble. We are in a crisis, and that crisis is affordable housing. Reactive versus proactive management techniques utilized may obfuscate the current housing trust that seems to be insolvent. Proposal number 24 seems just to rectify that. The strengths in the proposal's allowance for multifaceted funding sources recently allocated but yet earmarked are a once-in-a-generation opportunity for affordable housing, as stated in the SLURF attachment mailed to Chair Herodopoulos. Here are just a few of these funding sources. National opioid litigation, roughly $25 million, or 4% of the 1.3 allocated in Florida. Emergency rental assistance, round 2, roughly $15 million. ARPA funds of roughly $30 million. Allocated, yet not earmarked, $150 billion in SLURF funds. And the May 16th letter that President Biden put out would allocate hundreds of billions of dollars for affordable housing. In the recent letter, allocating billions of dollars to local regions, that equates to hundreds of millions of dollars for various avenues and sources of affordable housing over the next decade, if dispersed through local, county, and municipalities. Effectively, we need to start with A, to get the money to person, C, the recipient. B is the minutia of this proposal. We are at A in crisis mode, and C, the recipient, will be the one that suffers. Yet that C class is growing exponentially, and soon the stats, like upwards of nearly 26% of investor-owned rentals, up from 12% in 2012 in Central Florida, will tear down the American dream. The American dream of home ownership will soon be a story we tell our children, starting with Once Upon a Time. So I implore you to ask, what is that general welfare? Well, I'm convinced it is life, liberty, and the pursuit of happiness, not only for you and I, but for our posterity and for our legacy. It's that Plamora, it's that Philosopher's Stone, it's that Midas touch, it's that ability to make something out of nothing, to get this idea in this head and to each and every one of your heads over there. It's language and it's vision. I asked you if you've ever had a dream. I have. I've had a dream, and I still do. I dream that we will see a day when the American dream is within all of our reach, and we will strive for that excellency. I'll end with this. The court of public opinion has spoken, and the frequency of newsworthy articles being disseminated by the press are on affordable housing and the ensuing crisis. Lastly, this is not the alternative presented. This is the solution provided, the only solution provided. This is our freedom. And I want each and every one of you to be free and have faith. Have faith that with a yes vote on proposal number, one sentence.
Sure, go ahead.
Thank you. On number 24, you will be hastening the arrival of affordable housing for the way of the future here in Brevard County. Thank you.
Thank you. All right, we had Janice Crisp. Is she still here?
Yeah, she will.
Okay. Rosa Reich.
Good evening. I'm Rosa Reich. I live in unincorporated Melbourne County. I've had 22 years of experience in affordable housing, half of it with Brevard County Housing and Human Services Department, and the last half of it with nonprofits in Brevard County. During my time, both county and outside of it, in the good years, we don't talk about affordable housing. I would get calls by the county, well, how dare you do this project in my area? NIMBYism. Then a couple of years later, the same people call me up, my neighbor, they've lost their housing. What are you going to do about it? So again, when it's a crisis for everybody, then we need affordable housing. When it's not a crisis, except for a small group of people, there's no need for affordable housing. What is being proposed here, for various reasons, I totally agree we do need a housing trust fund, one sort of another. We get SHIP funds, as was stated, 65% is for first-time home buyer. The problem with SHIP funds, as we've talked about, they get swept away. We get home funds from HUD. A lot of that's used for home buyer repair and so forth. We do create some affordable housing with it. But they're controlled by the feds, controlled by the state. If we can create a locally controlled funding source with our own ordinances, our own rules, we already have some of those in place. This would allow us to fund it and create the affordable housing we need without having to be tied to federal and state regulations that we do not control what we need in Brevard County. Thank you.
I have a question for you, if you don't mind, because I don't think a lot of us have expertise in this. You clearly do. What is a typical amount given to an individual in the course of a year?
Okay, so let's talk about affordable. If we're going to talk about SHIP funds and home funds,
okay,
they're not given to the individual necessarily. If we do home SHIP funds, it's the first-time home buyer program, so it buys down the mortgage and allows people of moderate means to buy into the American dream. They get a house, they develop economic wealth, and so forth. They have stability in their house. The county puts a lien on that property. It's 10 years. It's forgivable 10% every year for zero. At the end of 10 years, it's forgiven. If the family sells the house, they get to keep the profit. They've increased their value. If they sell the house prior to that 10 years, the county gets part of it back, okay? So that part helps. When it comes to the repair, again, it doesn't go necessarily to the client. If a client calls in and they get on the wait list with the county, said, I'm 65 years old, I can't repair my house, air conditioning is broken, whatever the qualifications are, the county then sends out their inspectors, verify the stuff, they contract out, and it's repaired. Again, it doesn't go to the person. So I don't have the most current statistics. 10 years ago when I was doing the business, I probably would have known it off the top of my head. Now let's talk about rentals. Having come from the not-for-profit world, we would average sometimes paying 2-3 months worth of rent, and we're talking about $3,000, $4,000 sometimes for an individual and paying rent. For us to house a family who got homeless, let's say they lost their job, got kicked out, they're couch surfing, now they got a job, they're stable. One of the things we're required to do as nonprofits was to verify that they can continue to pay rent. But again, we're now, as a nonprofit, paying out first, last security. So you're talking about, we were averaging $3,000 to $5,000 per family. And we usually try to do it in a one-time year, but sometimes things happen. If we create affordable housing and we can buy down the cost of that construction, then what happens is we can stabilize the families, we can use this money to help families out, and it would not impact the social services impact, but it also impacts taxpayers. And the reason I'm bringing that up now, because that's something we haven't talked about. When families are in crisis and they become homeless or near homeless, they tend to have other mental health issues. There is trauma involved, domestic violence, the police are involved. If they become homeless, they may have lost their insurance, and they now use the emergency rooms as their primary care doctor. So it's a whole slew. The children suffer in school. So it's a whole slew of things. When we talk about affordable housing, it's not just keeping people housed. It is talking about the social fabric of our community and keeping people stable and what they go. So to put a price on how much people get per year out of it, it's not like Section 8 where they get a voucher. It's not going to be that. It's going to buy down the property, make it affordable so they can stay in their housing.
Explain it by buy down the property.
So, for example, let's say developer, and it can be a not-for-profit developer or for-profit, whichever works. So they have a project that might be $2 million. Now, their cost per unit would be, fair market rate might be $1,400 a month. If the county brings in the money and they buy down, then they say, okay, we can now rent these places for $1,000 a month. And we agree to do this for a certain period of time, 10 years, 20 years, 30 years. So that's one mechanism to do it. There's many other mechanisms, and maybe one of the speakers behind me might speak on that issue, but that is one of those mechanisms.
On the SHIP specifically, when you said that buy down the mortgage, it was basically, let's say they need a $150,000 mortgage, and then the county's contributing 25 or 50, whatever.
Much less than that, but yeah, around that
and
time.
then it's forgiven, like you said, 10%. Okay, got it. Because I used to be a mortgage broker. When you say buy down, I think rate. Right.
Sorry about that, yeah.
So I mean, again, I'm just trying to understand, going back to my question to the sponsor. If we had $10 million in this fund, how many families are we helping?
Well, today's prices with the construction, it wouldn't be as many. And like you had mentioned earlier, there's probably going to be a softening and maybe a slight crash of the housing market, and we'll see some housing prices fall as well as construction materials. That I can't answer because I do not know what the current construction costs are. But there's so many other mechanisms like I'm a member also of the Brevard Homeless Coalition. I'm an advocate for affordable housing there. And there's also something we're looking at, it's called community land trusts too. So there's so many other mechanisms that we're going to then put into that, and that's going to be a much more tedious thing. But one of the reasons I also like about Mr. Chandler's proposal is we're not tying down to the county ordinances saying this is what we're going to do and how we're going to do it, because there's already incentives. Mr. Perez, you had mentioned about the ordinances about density. Under the SHIP plans, for us to receive SHIP funding in Brevard County, we have to have a mechanism to incentivize the developers. So that's why it's done through the ordinances. And so every few years it's reviewed, it's sent to the state, it's passed by the county commissioners and so forth. There's a whole mechanism of that. So it needs to stay in the ordinance field. It cannot, and it should not really be in the charter, okay? Because, again, we're dealing with the state for some of those incentives, and there might be some. And 5 years from now, the state may say, we want these kind of incentives. We don't want to tie our hands up.
So it shouldn't, or should not be in the charter?
Should not be in the charter. I think through the ordinances, and we already have them in place, is the correct mechanism.
Okay. I'm sorry, Mr. Fisher.
Yeah, Mr. Chair, something I think, Jordan, you might want to think about is, part of the issue of this affordable housing is land costs, construction, permitting, impact fees, and all those type of things. And I think the county has some excess land, and I think that that's an area that you could possibly look at. And with that, if somebody's willing to put an affordable house on it, then county might be able to cut a break on what that land cost is. I think impact fees and permitting is a serious issue, and that costs for the developer. Maybe some possible tax credits for making that investment. I think doing those type of things will probably be an easier sell, and then mandating the county commission put dollars aside.
We looked at some of that stuff 20 years ago about the impact fees, and of course, SHIP funds could not be used to pay down the impact fees and so forth, and how it was going to affect the affordable housing. So those are mechanisms to look at. The other thing too, we've had a bit of a housing boom. We haven't talked about that, and again, that I think is more in the purview of the county commissioners. Can they look at the excess, if there is an excess in the impact fees that are coming in with all this construction boom, can some of that then be put into the trust fund? So there are, like I said, so many mechanisms that, again, if we, those are things that need to be discussed, but we also want to not tie it down necessarily in the proposal, because being in this field for over 20 years, I've seen things come and go so rapidly sometimes, and you're preparing one way, and as someone has said earlier, it can take 3 to 5 years to develop an affordable housing project. Sure. You're going one way, then suddenly, now best practice across the country is to do it this way, and now we have to suddenly change, but 6 years later.
Fisher's point, if there's an in-kind services or the fees that the county could waive,
Right.
at least it's not coming out of actual tangible dollars,
Right.
but there's still the savings that are accrued. Correct?
Exactly,
Okay.
exactly. And as Mr. Chairman, I believe, correct me if I'm wrong, in your proposal, you said there can be a donation of property into that trust fund. So that's where the excess county property can be put into there
Sure.
as well.
Well, it's been helpful. Thank you so much.
Certainly.
All right, well, we have Drew Warren, I believe. Rosa Reich. Welcome.
Hey, thank you very, very much for bringing this up, Jordan, and thank you all for listening. I want to start by, just saying this is not a political issue. This is a practical issue. I happen to be more conservative than some of you, but I still see that this is something that we have got to invest in. We have got to get ahead of the curve on this, and we're right now really behind. So, again, my name's Drew Warren. I'm the Executive Director of Community of Hope. We have been housing homeless and low-income families for the last almost 20 years. I've seen lots of faces in that time. And the faces I'm seeing now aren't, the typical faces that everyone thinks of when they think of homelessness. They're our mothers, our fathers, our children. They are just like you and I, except right now the cost of housing is so prohibitive that someone on a fixed income, the elderly person on a fixed income, just cannot continue to afford rent when their landlord is increasing it to meet the market rates. So I'd like to say that over the last 5 years, 211, as you know, is kind of the place that people call if they have some sort of an emergency that's not a 911 call, but a social emergency. And over the last 5 years, the number one reason that people call is related to housing. So, and that seems to be the case every year. Matter of fact, in the last 5 years, the top 3 always included housing and utility assistance. So again, this is something that the constituents of Brevard County really have an issue with. Secondly, Jordan mentioned the Schimberg data, and I do encourage you to go look at the Schimberg data through the University of Florida. But in the last 10 years, the county has increased in approximately 75,000 people. In that time, we have actually decreased our number of affordable housing units by 335. So we're increasing population, increasing need, decreasing the supply. And this is an opportunity to say, hey, county commissioners, we're going to take this seriously. Please put this on the agenda. Make sure that we find a way to fund this year in and year out. Somebody mentioned incentivizing developers. Basically, that's what this is about. This is about finding a way to tell the developers, whether, like Community of Hope, we do some development. We're a community housing development organization. That here's some funding, here's a funding source, not to fund your entire project, but to operate as a seed to help get the other funding needed to get the project going. So that's all I've got. Thank you.
Very good. Questions? Thanks for your time, sir. Thank you very much. All right, we've reached the end of our agenda. There's no unfinished business, I believe. Are there other comments for the good of the order? We have our next meeting on July 7th, correct? And we'll take up those different proposals, be thinking about the one especially on the special elections and the appointments, et cetera, as well as Mr. Roderson's and others. Obviously, Jordan has, on this issue, a couple things to talk about, so we'll have a good time. So with that, Mr. White moves to rise and adjourn.
The opinions expressed by any member of the public during any period of public comment do not necessarily reflect the views or opinions of the Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, or the program sponsor, and are solely those of the presenter. The Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, and the program sponsor hereby expressly disclaim any and all responsibility or liability for any defamatory or slanderous statements expressed by any member of the public